which is being supported by Ministry of MSME. And we are working with different clusters, pan-India, to raise IP awareness. And Mr. Shravan Kumar Bansalji, advocate and senior partner, United IPR. So they are there, they have always been there to support and guide us in taking the IPR awareness at the grassroots level. Mr. Sudarshan Kumar Bansalji, thank you so much for joining with us today. And Dr. Blossom Kocher, I think I'm grateful to ma'am for joining us today. She will be sharing her, there is no introduction which is required of Blossom ji. She will be sharing some practical insights, how IP is important for women. So we normally take it, oh, it's not important to get it registered, but how important it is and how it is going to have fruitful business propositions in the long run for women. It's very important. There is a saying that countries who have strong copyright regimes, a research was done that that country is having maximum number of artists. So this is important because when we register our IPR, so I'm glad to see all the young ladies here. And please, deliberate with the expert line of speakers who are present with you here today. And we are having Dr. Prakash Ambalkarji. Dr. Prakash is there online. He couldn't join us because he is in Bhopal. And Mr. Naveen Mathur, Joint Controller of Patent and Designs, which is under Ministry of Commerce, Government of India. Thank you so much for joining us. And with them also, with the ministry, we have whole PhD chamber has held several webinars, several events together. And of course, to I welcome Secretary General, Mr. Saurabh Sanyalji, who has always been a mentor, a guide in taking us forward in this IPR facilitation. And I'm grateful to you, sir, for joining us here today. Now, without taking much of time, I welcome Mr. D.P. Goyalji, co-chair MSME committee, to kindly give his blessings and give the welcome address and start the proceedings of the day. Over to you, sir.
Thank you, Ms. Kanchan. Good morning. Today's topic, Women in IP Global Networking Event 2022. I welcome all the delegates, speakers, participants to this seminar today. It is a session on intellectual property, is much awaited topic to be discussed, and it makes more interesting to have included women in this discussion. Disparities exist on the use of IP system by women. Gender gap in innovation is narrowing down, but the progress is still slow. The main objective of this session is to encourage more women to showcase their talent by promoting gender equality and diversity in the innovative and creative sectors, and also to protect the women working actively in the field of intellectual property. A very warm welcome to the eminent speakers who would be sharing their insights today on the topic, Women in Intellectual Property. I also welcome all the participants who took out their valuable time to join us in this seminar. I hope all you have a wonderful experience listening to our renowned speakers who are subject masters in the field of intellectual property. Today's webinar is being organized by PhD Chamber of Commerce and Industry in collaboration with United IPR and supported by American Intellectual Property Law Association. The role of women in IP is occasionally discussed but not frequently studied. Over the past few years, increasingly, researchers, IP offices, and governments are beginning to ask interesting questions around the representation and participation of women in the creative business. Intellectual property rights is an inevitable tool for today's globalized economy. Fostering innovation is one of the sustainable developments and the goals set by the Government of India. In India, where intellectual property stimulates creativity and innovation for the benefit of all, is the vision of the National IPR policy. Several initiatives have been taken and proven to foster innovation like the Make in India, Startup India, Digital India, and Skill India. The Atal Innovation Mission nurtures the innovative energies across the country in schools and universities. Under the IPR policy, the Cell for IPR Promotion and Management CIPAM has been tasked to facilitate creation and commercialization of IP assets in collaboration with the Office of the Controller General of Patents, Designs and Trademarks. The filings for IP rights have considerably increased, and the intellectual property offices are also getting revamped in terms of capacity building. More examiners have been recruited and trained in patents. The patent office started functioning as international searching and examining authority since October 2013. It is encouraging to note that more applicants are now choosing IPO for international research. To ensure quality in all our operations, a dedicated quality assurance division has been set up in the patent office. With all efforts in place, it is expected that IPO would leap to even greater heights. Let us now begin the session by listening to our esteemed speakers who are here to share their experience and valuable inputs on the topic. Thank you.
Thank you, Goel sir. And I think he has set the tone for the event and has elaborated all the initiatives which are being taken by the government for the promotion of the IPR, whether it is startups scheme. We have recently seen in the budget that there were many the budget has been sanctioned for R&D and all. Though of course it is less, and from the PhD chamber we are taking this forward that more of R&D is required, not only in the government side, but also in the private sector to take this innovation forward. Now, I would like to call upon Mr. Shravan Kumar Bansal, Advocate and Senior Partner, United IPR. Over to you, Bansalji, for the theme address.
Thank you, Kanchanji, and thank you, Mr. D.P. Goel, for their valuable inputs. First of all, I just want to extend my gratitude to PhD Chamber of Commerce for organizing this event. And also the support which is rendered by the AIPLA, which is the American Intellectual Property Law Organization. This is a great endeavor which you have done. That is really remarkable. Now, IPR is always linked to the economic growth. See, this is, everybody knows, this is the life and blood of the business enterprise. Now, with the passage of time, how the IPR basically has developed, that we have to see. Women has always played a pivotal role in development of IPR. The live examples today are the creation of the intellectual property divisions, which is a specialized course in India, which are headed by the two lady judges who are specialized in IPR. So this is again a very remarkable achievement where the women power can be seen in the IPR world. Then my experiences shows, some time back, women used to be only, researchers, and they will be more concentrating on the IP prosecution part. But now I've seen, the women coming forward and contesting a lot of these complex cases of patents, trademarks, and designs. So this is really remarkable. The, some of the examples are, the famous Novartis case, which was contested by the lady lawyer now who's become a judge, Pratibha Singh now. And that laid down the foundation of 3D, Section 3D of the Patents Act. The efficacy part, which was discussed by the Supreme Court, that was again argued by a women lawyer. The second matter was the Cadila case, which is again a very, very important case where the guidelines were laid by the Supreme Court of India for enforcement mechanism, especially pertaining to pharmaceuticals and medicinal products. So these were all basically great achievements where the lady, the lawyers which were involved. So now there is a transformation which I have seen. See, earlier from the researchers or only basically providing a backdrop services, now they have come in the limelight with regard to the active litigation part. So this is something really great which has happened from time to time. Now, coming forward about the AIPLA, basically, I just want to basically highlight some provision because they have actively supported and had a faith on the Indian law. So this is something again very remarkable that the foreign organizations are coming into India. They are supporting the IP mechanism in India. This is again a very, very remarkable thing. Now, about IPLA, AIPLA, I would just like to basically highlight some of the salient features. American Intellectual Property Law Organization Association, founded in 1986. This is the American Intellectual Property Law Association with the core mission has strived to uplift IP professionals. Celebrating its 125th anniversary that year, the AIPLA is valued pursuit of excellence and commitment towards the improvement of IP system and collaboration of building a strong, diverse, and supportive community of diverse IP professionals over the years. With over 8,500 members worldwide, notably the AIPLA is presided by the IP attorneys and practitioners who have contributed to protecting the IP of various groundbreaking innovations. AIPLA has also dedicated Women in IP Committee with a mission of inspiring and empowering women in the IP reach to their potential. So these are the certain highlights of the AIPLA. So this is something, collaboration, the American organization collaborating with the PhD for organizing this event. This shows that how basically the IP is developing in India. Even the government is also focusing extensively on the IP development in India. This is something. Now, I would like to share some of my experiences, how it happened, how the things have changed in the last 15 years. I remember, in 2005, 2006, I was attending one of the seminars outside, IP seminars, and there was one Australian gentleman who walked, and he basically contacted me and asked me, see, Mr. Bansal, you are from India. See, please tell us how this, can you show me how this trademark registration certificate looks like in India? I have not seen a certificate. Can you show me a patent certificate looks like in India? I have not seen a patent certificate in India. So this was a position which happened in 2005, 2006. Now, thereafter, there has been a remarkable change, both on the prosecution side, on the litigation side. In case I see on the prosecution side, see now the trademark registration you can get at a straightforward case in 9 to 10 months time. The patent registration basically can be granted in about same in 9 to 10 months time in a straightforward case. So this is a remarkable. Digitization has happened, the modernization has happened, the data collection has happened, examination is up to the level, that is a position. So a lot of reforms on the IP prosecution side is taking place. Then on the litigation side, we have seen recently formation of the commercial courts. Now, the IPR regime now today is a part of the Commercial Disputes Act. So on the fast track basis, the specialized commercial courts to deal with this particular aspect. This is again a very remarkable achievement. Then 2016, there was IPR policy. The government of India took out the IPR policy. Now it is mandated that every police official should go under a IPR policy training. A training program should be there. So this is again a very good endeavor where a lot of these. Now in the courts we have seen, there was a mindset earlier. Like, the plaintiff side would be normally a multinational company who is enforcing the right in it. Now, the defendant side would be primarily the Indian company, and the mindset of the judges were like, the Indian company would be the infringer. He must have copied a brand of the other side. He must have copied the patent of the other side. But now the scenario has changed. We find a lot of these patent enforcement is taking place by the Indian companies. Why? Because the position is a lot of these patent filings are done by the Indian entities. A lot of these R&D is received, and the filings are also done. Even the government of India is providing funding. Tenders are floated. Now the position for the first time, the IPR tenders are floated by the various government of India organizations, and some of the, for example, IT institutes and so on. So when the filing comes, the funding is done by the government of India. So much of basically work has been done on that. Second aspect was the task was also there to make IPR enforcement effective and budget oriented. So this is again, we have achieved like this. I can also share my experiences when we go and contest litigations in overseas countries. Like suppose we contested some litigations in China, we contested some litigations in Europe. It is so expensive, and the business entities may not be basically able to, afford that, and they end up in compromising the matters only because of the budget constraints. But in India, I have seen, the IP enforcement basically has become so economical, it's so effective. Like, it is not that you just go to the high courts for enforcement of your right, for vindication of your right. You can even go to the district courts. Even like the police officials, they have the power in certain cases of trademarks and copyrights where they are cognizable offenses. You have not to go to the courts at all. You can even go to a local police station, file a complaint, lodge an FIR, and basically have your rights enforced. In case the goods are coming from outside, the custom laws are also there. The notification of 2007 which came, where the IPR was linked to the customs. Like, it is not necessary like, the import consignment, you go in the market and rate them. You can file complaint with the custom authorities and you can have your rights basically adjudicated by the customs and also enforced by the customs in a very, very effective manner. So these are great, some of the basically limelight which has come into that. Even on the procedural part, like, especially I should really applaud the patent department, the way they have worked. See, our Patent Act is so balanced in the sense they protect the rights. Like when you grant a patent, you grant a design to somebody. It's a reward. It's a reward which is basically given to the inventor or the originator. It's a reward. So naturally, once you give a reward, it's the duty of the patent department to basically protect those rights in a fastest possible manner. Suppose it is taking so much of time because the life of the design of a life of a patent is very limited. It is not like a trademark which is perennial. Every 10 years you keep on renewing it. Like life of a patent is only 20 years. Life of a design is only 15 years. Earlier it was seen by the time the patent is granted to you, the life is already over. You just have 1 or 2 years to basically just enforce those rights. So today, when you are basically getting a right in 1 year time, you have 19 years. You have 19 effective years to basically enforce your rights. So this is a reward which is given to the inventor. So it is not only like, the industry is protected, the inventors are also protected. So this is again a very remarkable thing. The timeline have reduced to a larger extent. So this is there. As I said, the patent law is very much balanced, where the rights of the right holders are also protected, but it is also to be seen that the frivolous patents does not go on record. So like, once my patent, there's a real efficacy involved, there's an innovative step which is involved, there's an industrial application, there is a economic significance which is attached to a patent, then the patent offices are granting patents in a very rapid manner. But in case there are some frivolous patents, it's an anticipated patent, or there is no novel characteristic into that. Even the provisions for filing objections on behalf of the objectors are also there, which can be filed at 3 stages. There is a pre-grant representation, there is a post-grant representation, and even after the grant of a patent, even the revocation system is also there. So what I see, the balancing act, that is really remarkable in our regime. Like, the rights of both the patentee as well as objectors are equally protected. And this is the position with regard to the other intellectual property rights also. So the position is what I feel on the basis of my experiences, like, our IP system is very far developed. It is very well developed in case we see to the other countries. Even if I compare to the developed countries, we have a very, very effective mechanism that we have. Naturally, there are certain shortcomings to which we have to overcome, and for which the organizations has to come forward, especially the cases where the damages are to be granted. It is not only the interlocutory orders which are there, because the right holders, basically, when their rights are infringed by somebody, it is not only their rights are infringed, there is a loss to reputation, there is a loss to, in the financial loss is also there. So that is also to be compensated. So I find in certain these areas, we need to progress more. Like, the damages should be granted more rampantly. The costing should be granted to the right holder. He should be compensated. There we are lacking. So this is something, the reform that we have to do. So these are some basic things we have come, and I really appreciate the position. We have the eminent speakers today, and we'll be sharing. We have from the government departments, we have from the industry, we have. And then naturally we have from the audience also, budding some lawyers are also there who will be definitely, joining some industry or basically coming into the practice. So their, their contribution is again really immense. So with this, I know I close my representation, and thereafter I'm always available for any question and answers. So thank you very much for this.
Thank you, Shravanji. And I think rightly you have highlighted all the initiatives of, how our IP regime has become more robust in our country. And as a Chamber of Commerce, as PhD Chamber, under the dynamic leadership of our Secretary General, we have been a part of this journey. We have seen it has actually worked, training of police officials, how, as rightly you have pointed out, now we don't need to go to any specific police station. Complaint can be done in any kind of a police station. So with all these things, our system has strengthened. And of course, there are certain things which need to be taken care, which from the chamber we will surely take it. As you mentioned, this damages, this is an important part which we will surely represent to the government. And I am thankful that Mr. Naveen Mathurji is here, who will be highlighting more on it. Now, I would like to call upon Mr. Sudarshan Kumar Bansal, Advocate and Senior Partner, United IPR. Over to you, Sudarshanji. It has always been, a privilege listening to you, your wisdom, because you are in this industry, in this profession. So there cannot be a better person than you to talk about how it has evolved, how the IP journey has actually evolved.
Thank you, ma'am, for this generous introduction. I'd like to have my gratitude to PhD chambers and to the MSc through Mr. Goel and to Mr. Mathur, so from the Office of the Controller General and the other speakers, and of course to Shravan, my fellow partner, and with United IPR. IPR's need, importance is well settled. I will not dwell too much on it. We all know it fosters innovation. It's an engine for economic growth and so on. But IPRs by themselves can never be taken in vacuum. They have to be considered in a very pragmatic and a practical manner. As it was pointed out, it's a great adventure. There is no doubt. It's an adventure to growth, adventure to recognition, empowerment, and a feel-good factor as well. And a person who makes an invention and gets a patent or a design trademark is a feel-good factor also attached to it, that I've achieved something. As someone pointed out, it's a reward. So this reward makes us feel good. But in any case, for the success of the IPR regime, there are certain fundamentals that must always be kept in mind. Number one is that the IPR that one seeks must be well identified. One must know what he or she wants. Whether it's a trademark, then it's a trademark means whether it's an invented word, it is this, it is that. Similarly, for the patent side, we all invent. I mean, there may be inventors in the laboratories, but to use it, I mean, from a patent perspective, it must fulfill the basic criteria that the Patent Act sets out. There must be an inventiveness, obviousness, anticipation, efficacies, etc., etc. So all these does require something more than just a mere invention. It must be well utilized, it must be well used, and then well exploited. So these are certain aspects which are also very important, and not just a matter of, I would say, just not a matter of emotion. The intellectual property rights in India has a history. In 1911, the Patent and Designs Act was passed by the then legislature. The Patent and Designs Act of 1911 held forth till 1970, when the Patent Act was enacted, where the patent component was taken out from the Patents and Designs Act of 1911, and a specific statute known as the Patent Act of 1970 was passed. In this act, over a period of time, having regard to various international treaties, obligations, experiences, demand from the industry, stakeholders, from educationalists, from the think tank, etc., the Patent Act over a period of time underwent numerous amendments, not just one or two, but many, many amendments. The Designs Act of 1911 held forth till the year 2000. I mean, when the Designs Act was repealed, and the modern Designs Act, having regard to the international experiences and international scenario and economic realities, came to be passed. In the Indian context, presently, the patent regime is governed by the Indian Patents Act of 1970, as I just pointed out, which came into force in the year 1972. The Patent Act was again amended in the year 2005, as I just pointed out, from 1970 to 2000, because we had a very controlled economy. It's only when liberalization came and the importance of IPRs or the thrust of the Patent Act or the patent regime became a more reality. International scenarios, think tanks, international treaties, etc. Where the product patent, and previously we were just had the product patent, but now the process patents also get added on. In 2005, just as an example, in 2005, wherein the product patent was extended to all fields of technology, including microorganism, microbial organism, chemicals, foods, and drugs. The patent laws were initially framed from chemical, mechanical, and electrical invention point of view, but later on, information technology, electronics, pharmacy, biotech emerged as a chief field of intellectual property rights, resulting in change in prior law. Additionally, the present Patent Act covers all aspects and relevant provisions of TRIPS, the Paris Convention, and the Doha Declaration. As I pointed out initially, international treaties and international movement of ideas also shaped our Indian patent law. India has made successful efforts in removing the ambiguities in the Act and making use of flexibilities offered by the agreement to serve the best interests of the nation. The amendments in the Indian Patent Act scenario have brought about positive changes like reduction in certain fees payable under the Act, simplified and digitized procedure for application for patents, recognition to international applications, protections to traditional knowledge, and a more clear and crisp definition of invention. The most recent notable amendments is the abolishment of the Intellectual Property Appellate Board and the establishment of and the pass from the Intellectual Property Appellate Board to the High Court, and within the High Court the establishment of an Intellectual Property Division, which is called the IPD in the Delhi High Court. Since we are celebrating women in IP today, the noteworthy amendment in the Indian Patent Act is the inclusion of at least one female applicant, resulting in expedition of the patent prosecution process. Indian government has taken various initiatives to make the patent process easier. Patent can be filed in all 4 metros. The IP rights provide monetary benefits to inventors, further creates environment for competition, which is good for the growth of the economy. Now, not only filing in the 4 metros, but also the hearings now are taking place through the virtual mode. So people don't have to physically go to a particular patent office. Many times if objections are raised, let us say from an applicant who's subject to the Delhi office, and an objection comes, let us say from the south part of India. Now we all can assemble over the virtual mode rather than, it saves time, it takes effort. As Mr. Mathur, the Learned Controller General, would also agree, over a period of time, the examination system has also become more accurate. Objections that are raised are more clear, specific, so the industry or the applicant knows what he or she has to meet. Hearings are granted quite quickly. Of course, there is always scope for improvement. As industry and think tanks meet, stakeholders meet, there will always be betterment. It is also believed that IPR creates monopolies and could increase the IPRs. Of course, there are many people who have their own views. For example, many believe that IPRs create monopolies. Prices get the people just added on to the price of goods. So what would cost X amount of rupees would now get the IP component, the Y component may be much high. So X plus Y, the pricing may be also very high, thus affecting the many people, the many people from the industry or from the media or from the think tank or from stakeholders believe that the poor people get marginalized, especially in terms of farmers, where the pharmaceutical drugs are overpriced or the pricing is beyond the reach of them. We found a big debate that took place during the COVID times of availability of essential medicines and how the patentees who held the patents could, in a way, dictate a price which may be beyond the reach of, or maybe beyond the social considerations of our country. But all these are issues which can be addressed. IP regimes do address it. There is a licensing regime. Ultimately, more people who enter the IP market with the regime would have a positive impact on the market. There will be competition. This is what I believe. A balance is required for its use and to prevent misuse, which only be made by making careful laws and its effective implementation. The survey noted that 58,502 patents were filed in India in the year 2020-21, up from 45,000 odd in comparison to 2016-17. Similarly, 28,391 patents were granted in India in the year 2020-21, up from roughly 10,000 in the year 2016-2017, and 7,000 odd in the year 2010-11. So there is an upward trend. People are joining, people are availing of the benefits of the IP regime. People, and including women, are filing more and more, which is a good sign because it shows that there's awareness and the market access that an IP right does deliver or does open up is very important, and which is an avenue which must be well exploited. After all, to have access to a market, and if you enter the market with your IP rights, you're well protected, not only you're against others, but you can also exclude others. So this is an important aspect. Although there is significant rise in patent filings in India, it is severely behind when compared to trademark filings in India. Trademarks and patents as of now are not at par with each other in terms of the filings. The trademarks do outbeat the patents, but I'm sure with the passage of time, patents will also catch up. An average of 3 lakh trademark applications were registered in each of the last 3 years from 2017 till date. As per WIPO's World Intellectual Property Indicators 2021 report, around 14 lakh patent applications were filed in China in 2020, whereas in India, which is ranked 7th globally, has around just 56,000 patent applications. So which is a big, the distance is quite large between India and its immediate neighbor China. So this, I think, is also an issue which must be addressed. Industry, women, all the people who are there, inventors, must come forward and utilize it. After all, China, I mean, I'm not holding any brief for China, but we all know that China has made considerable economic progress. India has also made it, but a well utilized patent regime would enable us to narrow the gap and perhaps even overtake it. We have many advantages. We must exploit it to the full. Even though India is a growing economy and competing with many countries, the improvement in the Indian patent scenario is highly affected by lack of recognition in the pharma industry being a powerhouse, and India still being considered as a developing country. It is very essential, according to me, to rebuild the image of the India IP landscape and also to increase its field and applicability to address many more issues and to make it a little more clear as to what is an invention, what is anticipation. One need not go to a court of law every time. Litigation, courts of law do take time. If at the patent office itself, at the initial stage, greater access to the examiners, greater access to the controller, at the first instance itself, not just facilitate, or to the chambers or to many industrial organizations, to lawyers, associations, or if they themselves can be more easily accessible. So the right holder or the patentee at the first stage can get great advice, good advice as to how he can exploit it. This would, I think, in my understanding, would greatly help in our regime and make it a better regime, rather than going to the patent office or going to the court of law, going through the rigors of, after all, even in the patent office or in court of law, it's evidence-based, adversarial litigation is there. There are a lot of factors come in. Many things may not be in our control. There'll always be an opponent who has his own thinking on the subject. These all add to cost. These all add to time. So if at the first instance a greater facilitation is provided, which can iron out many things at the first step itself, I think would greatly help our patent regime and other IPRs as well. With this, I would like to close and thank you, everybody.
Thank you, sir, for your words of wisdom. And I think you have given some practical insights to all the, women who are here to, this will really help them in their journey of life. And now I would like to call upon Dr. Blossom Co-Chair, Entrepreneurship, Women and Child Development Committee, PHDCCI. Over to you, ma'am.
So good morning. Is it all? Okay. Good morning to all the dignitaries and participants. It's on. Okay, I've got to bring it closer. Thank you. Thank you. And of course, it's such a pleasure to see so many bright faces, young, bright faces here. And of course, and so many women also here. It's really wonderful to see you all in this, because and before I go on to anything, I would like to say that I would like to thank PhD Chamber of Commerce and Industry for organizing these kind of seminars, and they encourage more and more people and more young group of people like you all to focus on intellectual property and get their ideas, or a piece of work protected through the intellectual property rights, which is very, very important. I'm going to tell you because I face those things. The women participation is also increasing, I must say, in the field. And PhD Chamber of Commerce and Industry, by the way of organizing this seminar, will surely impact a large number of women folk. I'm sure you'll all agree with me. It is there. And I must say a big thank you, of course, before I go on also, like you all have all heard about from Shri Bansal ji, and of course, Shri Goyal ji and Mr. Sudarshan Kumar Bansal, about what they've been saying, which is very important, And I must tell you before I start to say anything else, that I've started my business, of course, very much long ago. And there wasn't very much of these intellectual rights or anything like that. And when I started, and by the time we were exporting out, so it was in two fields. One is exporting, and the other was when I was teaching and the books and the other things that went out, education. So the education part, I'll stay first. It happened with China. I had to go and teach. I teach all over the world. So I taught in China, aromatherapy and this thing. And then what happened, before I knew it, all the videos and all the knowledge was out in America and all stamped by them. And when I looked at it, I said, this is all my stuff. But by that time, that's when I really came to know a little bit about this. And I couldn't do anything at that time because it was quite early on when I started it. And then later on, of course, it was in the cosmetic field. I found that my cosmetics, we had the stamp on our same labels and things. There was other products in it, and it was exported all over. And that is when I really came to know, and I went across to people and tried to find out, but we weren't so strong. Now we are really strong. And so when it happened this time, about 2 years ago, we did it in about 6 months. Everything was caught and everything was put right. And now we know about all these things. So that is why I say it is very important. And of course, being a woman was even more difficult, but now there is no problem at all. And it is really something that I think we need to go about and really pay a good attention to. Because like I can see over here and in India, there are plenty of brilliant minds in the making, like all of you, I'm sure. And some of the most path-breaking ideas we've been coming from incredibly young minds around the country. And who knows, maybe one day, I'm sure we're going to see some of them and some of you also as heading successful startups, finding solutions to our 21st century problems. Like, for example, reducing pollution, switching to cleaner energy consumption, yeah, or fighting up plastic, plastic plague, that's another one. And they're changing the world one day at a time. You all are really doing it. The younger group is really doing it. And I must say thank you to all of you for helping the whole country to really, we do need that very, very badly, because intellectual property serves as the foundation of innovation in our country, in our economy, I should say. That is, and the government granted rights, incentive, discovery, and creativity by providing creators with an opportunity to profit from the value of their innovative work. In exchange, the creative work is made public so that others may build on and benefit from the work of the original creator. Laws protecting intellectual property also reduce the transaction cost between inventors and industry by providing information about the quality of the invention without jeopardizing the ownership of the idea. IP should be seen as a powerful tool for economic development. IP can be instrumental in keeping the competitive advantage for entrepreneurs and enterprises, and can help in getting innovative ideas and concepts for theft and enhancing the overall work of the company in the eyes of the investors. It allows the innovator to control and ensure the quality of supplies while maximizing the low cost for low and middle income countries. It allows the innovator to preserve the regularity to the cost from richer markets, leading to future investments from present investment. The focus should be on controlling the flow of information and knowledge, along with data, which is transformed into information, knowledge leading to innovation and development. IP is pivotal for Industry 4.0 is what we called as knowledge. We need to take control of information, i.e. to use knowledge to create new sources of economic opportunities. The control and flow of information need to be controlled, and which is being done, which we can see from all the eminent speakers. It is needed to be embedded into what and how we do it. Now, MSME is a sector that needs to be empowered, which is very important. And we are going to hear from that. I'm really looking forward to that. And they need to invest in building their IP. SMEs also need to be acquainted with the intellectual property system to avoid getting into activities that burden the legalities, at the same time ensure business success. The startups in other nations of the world use IP. They really use IP to leverage themselves in the market, which helps them to sustain, at the same time help them exist in the profitable way. The industry needs to handhold startups and pull knowledge, information, and IP from the startups. The invention is a black box that takes in money and produces knowledge. Invention and innovation need to work together for the success of economy and the society, which is very important. And I'm really looking forward to all of you all and the talks that I've heard and the whole thing. And I'm sure you're all going to enjoy this wonderful thing, this wonderful talk and this wonderful day. And thank you once again, PhD Chamber, for this wonderful opportunity for all of us. Thank you.
Thank you, ma'am. As rightly you have said that IP is an important tool for the economic development. And now taking it forward, I would like to request Dr. Prakash Ambalkar, CTO and Nodal Officer, Indian Council of Agricultural Research, Center Institute of Agriculture Engineering. Dr. Prakash will be joining us online. So over to you, Dr. Prakash.
Good morning, everybody. I feel honored and privileged to be a part of this August gathering. In fact, I have been working in this IP cell of the ICR Institute since the year 2006, wherein actually my experience suggests that there are technologies. Number of technologies, inventions are coming up fast in India, and they are being well protected also. There is a very good IPR regime working. Definitely, IP awareness is gaining momentum and at various with various stakeholders, not only academia but industry also coming up to aware the users of technology. But what my actually my observation is that patented technologies and their industrial application has a gap, and it is because market is volatile. And for gaining market, if we go for quality manufacturing, suppose, then price come at stake. So, but I am sure one day quality wins the race. So, but in the meantime, to exploit the market, basically, there must be a harmonious relationship between the quality versus cost. So, if we sacrifice some quality parameters, but at the same time we reaches to obtain the cost which is affordable to the end users, then it makes a difference, perceptible difference also, definitely. And those who are the end users, they will be benefited. So many of the technologies are there in various fields. But since I am from agricultural engineering side, so my view is that there are technologies like, for example, I would like to quote here, it's a very burning example also, that's sugarcane harvester. It's an expensive equipment, and its price actually goes above 1 crores, and that definitely a common farmer cannot afford that. So what's now it is going that in case if we want some R&D on it, its cost will definitely get reduced. And if that would be reduced, then this technology can be become more adaptable. And for that, industry should put some more efforts so that they can make use of this technology for the adaptation to the small farmers as well. So what's the trend is coming up that these technologies can be given on custom hiring. Means they can get the machine on hiring basis. And in case if that not only this technology, there are other several technologies are there which can be given on hiring basis to the small farmers. But my point is that it must reach to the remotest part of the country so that all whosoever are the end users, they must get the benefit out of the invention. So one point is that we need to reduce the cost. At the same time, quality is also one of the aspect. So here, other things which we can replace. Suppose, for example, wherever there is a more of the uh, metal component, that can be replaced by the fibers, etc. And so we can lower down the cost. And simultaneously, if the same technology can be widespread by its use, by more of the operational hours of the technology, then definitely that a total cost which is incurred on the equipment, that will uh, that will be ultimately become very much profitable from all point of view, not for the farmers farming community, but also for you can say that for the persons who are giving it on rent or custom hiring centers, as well as high tech hubs as well. They can also use the uh, more of the renting to the farmers. So this trend is coming up very fast. And now after that, in case if there is a huge production of suppose we go for a sugarcane, because I am quoting this example here, and then this sugarcane we can use for the production of ethanol. And that's as we are observing that the price hike is there in the fuel sector. Basically, we need to blend the diesel, etc., with the ethanol. And for that, our target is to reach up to 20% mixing of the ethanol. And that we can get through from agri sector. And a lot many biogasification and bioethanol, etc., we can produce. And that way, this IP can be well utilized. And there are several other examples also which we can code later. And though I will get an opportunity also to discuss on the issue with where my prime expertise exists at later in the technical sessions. And there I would like to narrate on some more points. But here, these are what specific to me, that when we come to use the technology, there must be a coordinated approach, integrated approach. All stakeholders come on one platform. They must discuss that who are the end users, who are the beneficiaries, from where, who are the manufacturers of the product of the technology, and who are the financer for the technology, and how it will reach to the end users. So these things are very much needed. So there will be a practical use of the IP component. That's what I observe. But slowly it is coming up. There are hurdles definitely, because our farming community is that way cannot afford the expensive technology. But there is a way out where we can uh, use these technologies and get the overall benefit. And this will eventually lead to solving all kinds of problems that what is being faced by the community as whole. So this is what is my actually my suggestions, or you can say that what I want to say from this side. And I am thankful for the audience for hearing me. Thanks a lot.
Thank you, Dr. Prakash. And rightly, you have put in that integrated and coordinated approach is required for making all the patents useful so that they can be taken for commercialization. Now, I would like to call upon Mr. Naveen Mathur, Joint Controller of Patent and Designs, Office of the Controller General of Patents, Ministry of Commerce and Government of India. Over to you, Mr. Mathur.
Good morning to all of you and dignitaries on dais. And thank you to PhD Chamber of Commerce to invite me at this seminar. It is, I'm glad to know that my earlier speakers, Shri Goyal Saab, Shravan Kumar Bansal, and Sudarshan Kumar Bansal, Dr. Blossom Kocher, and Prakash Ambedkar, has they have shared good things about IPR, enlightened you with the their experiences with the IPR. I'm also glad to know that Shri Shravan Kumar Bansal has acknowledged the government efforts, and really IP system is now growing very well in its working efficiency and its output. This year, this financial year, we have granted 32,000 patents, and it has become digital mode. You can yourself file the application sitting at home online. You need not to come to the patent office to file your application. You will be receiving your first examination report also digitally through emails. Those were not the provisions in yesteryears. So these were the difficulties with the government regarding processing of an applications. There were complexities in the IP laws also, that also have been to a certain extent removed, and the ecosystem has become quite supportive to the applicant, and for grant of a patent, many times the laws and rules have been amended. I will, by the talks we had by earlier speaker, I could gather some problems they were facing, certain issues regarding infringement of your IPRs. So all IPR laws are having provisions to file a suit against infringement in the various high courts, and these are dealt at the level and as per the laws. Recently, it has been IPAB has been scrapped, and as my earlier speaker has told you that there is a branch, special branch in High Court. So that will be a good effort to mitigate the problems and complexities, and you will be getting a direct judicial decisions. Our office is a quasi-judicial authority. With this and some problems which have been faced by cosmetic industries and entrepreneurs, I would like to say that all the IPs play their own roles, and it is a big challenge for a product how to include the various IP in its product. So with this all, I will start my talk about IPR. As you know, IPR has been a scientific, commercial, and industrial tool for the people who do mental effort and create novel, inventive, and industrially applicable knowledge, which give them exclusivity and consequently a right conferred by the state. So if you go by these wordings, then the major role is that it is conferred by the state. Whatever you do has to be conferred by the state. State means the government in our country, and that it is a monopoly, right? And the monopoly right actually comes by in our case it is governed, but it is a king, then it is given by the king. So such is the level, authoritative level of the granted patent or any other IPR. Of the IPRs like patents, trademark, designs, copyright, GI, trade secrets, semiconductor layout designs, patent leads the IPR in major way. Intellectual property, as the name suggests, is a property gained by intellect and should be gender neutral. If we measure the effort as the data of WIPO in 2018 report, India stands at 7th place with 23% of women inventors in patent filing. The question arises, are women less aware of IP rights? Certainly the answer is in positive, in my opinion. We have many women passing out in a STEM stream, that is science, technology, and engineering and maths. It is need of hour to make them aware about the IPRs. And I do not deny the fact that women are more creative and can bridge the gender gap in IPR in a short period of time. As governments are driving towards knowledge-based economies world over, the trade chambers of various countries are ready with their annual summary and scorecards of countries' IP system, labeling them as IP index. The index measures key indicators of a strong IP protection across various types of IP rights, commercialization of IP assets, enforcement, systematic efficiency, membership, and ratification of international treaties. These data, for example, USTR Special 301 review submissions, which will be shortly disclosed during this month, will reveal that countries with more effective IP framework are most likely to receive positive benefits, including more innovative and creative output, greater access to more innovative and creative goods, increased job creation in knowledge-based industries, greater access to venture capital. The very review, in my opinion, would also include how much each IPR is contributed by women, and index value should be obtained to increase more participation. Women participation in IP will create broader policy goals and IP justice, and will help in creating balance between domestic and international IP rights, taking into account the global public interest. And that is where all IP are related to. That any applicant or any person who is getting IP rights is getting its rights from the domain of the public interest. And that is where the applicant says that he has not received patent for such a long time and all that. But on the government side, government has to screen out, has to see the public interest. And that public interest comes in the way of various provisions of the Act, rules, and citations which we have. We can't negate all these things. So there comes then it depends upon how the patent application and which area of the patent application is concerned to. You have to concentrate on what is being claimed in a patent application and what is its domain, what is the prior art. So all these takes time to analyze. And we also don't want to give the frivolous patents. So there are various sections which have been provisioned into the Act to save frivolous grant of patent and then in fighting and going to the courts and various platforms. Women participation in IP will create a broader policy goals and IP justice and will help in creating a balance between domestic and international IP rights, taking into account the global public interest. There, I think the women will play a great role in this. They will be more judgmental once the IP right has been granted, and if it is in the litigation, they will understand whether at what platform the justice has been done or not done. So the woman has to step forward in this direction, and also the global knowledge, and that is a very vast knowledge. The invention which has been granted in US or any other country, whether it is having same force, inventiveness or not. If the US patent office has missed some citation, whether Indian Patent Office has been able to cite a document which is there in place for consideration. So if we have a, I think in organization, women forced to know the IP system and clarity about the invention, then a better justice, I mean, will be there, that they will accept, yes, the citation is correct, and you will say yes. On the contrary, you will say that yes, my invention is not invention according to the provisions of the Act. So instead of going to the court and various platform, wasting your money, energy, and all that, so that will be a great role. We have got many women inventors also, right from the field of weaving machine to bag making machine to algorithm to electric cooler and stem cells isolations. So what I gather from these field of invention is that women will be helpful in deciding, rather women inventors will be helpful in deciding the safety devices. Some invention has been made. Example, the inventor of wiper on the motor vehicle is woman inventor. right? From these list of things, what I conclude that this is what is missing in a device already invented, granted patent. The woman force will, if are aware of IP, then they will know that this is missing. This must be added. So that there an ingenuity will come from woman force. This EV electric vehicle have been invented, right? When it has been used, there will be some problems. Then there will be some solution from the, if it is from India, a woman IP force, I will be very happy. And I say that we have not directed woman mind into the IP scenario. So these most probably these inventors which I have listed will be are foreign inventors, woman foreign inventor. Our women should also rise to that standard, that platform. And it is when they are aware of their IP rights, they are aware of what IP is all about. And I think that this day is not far if awareness is there. As I already told that Government of India has amended its laws. We have amended Rule 24C in 2019 amendments. Previous to that, we were having 24B as a rule, which were saying that if the applicant or the application has been made, ISA international application has been made, and India has been selected as an international search authority or IPA, then expedited examination will be done. That is out of queue. There are several hundred thousands of applications in queue, and you will be given preference for expedited examinations. Then it was extended to startups also. But in 2019, government took an initiative that a female inventor will be also given the same privilege, and rules were amended, and new rule 24C was added to it. So this, in my opinion, startup and small entity, their fees were reduced, and this rule has clearly defining ability for the ecosystem, IP ecosystem. So it has included to whom we have to give privileges to. Similarly, we have created, we have undertook the awareness programs in our scheme as NIPAM. So it has also gone well with this period, and we have a target of 10 lakh audience who will, to which the IP awareness program will be communicated to in both digital and I mean to say a hybrid mode. Then we have, previous to that, we have got a scheme of Kiran, which is looked after by TIFAC, in which if a woman has discontinued its job by any exigencies, family's compulsion or like that, then she can have a introduction into IV field. They are trained by TIFAC and then again recruited by various agencies. And today's topic from the agenda, I see that there are two topics: overview of the Indian patent scenario, shaping advancement in technology and patents, and industry perspective. Both are good topics. I think you will be these topics will, I am sure that it will be elaborating your knowledge and your participation in IP ecosystem. And as far as MSME are concerned, there are many women workers working in different fields. So This IP system is IP types of IPs are also getting importance today because of our efforts to knowledge economy. The industry is also moving towards the knowledge-based economy and moreover to the digital economy. And I think those people who are working in these industries, and particularly women, are contributing a lot. And if momentary, if they have some idea or some innovation they have done, but they have not gone, they are not aware of IP, then they will let it loose and will not register their idea, or I'm to say they will not get a patent or some other IPs. That will a great miss to these people. So it is very necessary that you should be aware of your IP rights, not only for your rights. I will say that this will give a documentation that certain things, certain innovation came in your mind. Suppose you are working in a software industry, you did something good, and it has got a good technical effect. And now you will have to decide in future which IP, which part of your innovation will get a patent, because the work scope is getting changed, and past scenario of industry, of working people, how relevant they will be in future, I'm not sure. So you will draft your contribute to draft and define, rather not draft but define rather, what should be the invention, what should be the what should in knowledge term should be granted a right, and that to an IP right. So I came to know from today in discussion with the Blossom Kosciux was mentioning digital trademark. So it's really I mean to say that it's a really innovation. A digital trademark. You till now we are getting a trademark on a paper. Now, how to create digital trademark will be a hell of effort, which will require scientific effort, which will require legal basement, and how the trade will identify it, how it will drive into the lane of litigation. It's too complex. But there will be an ease for the customer, for the applicant. He will get immediately. The comparison at the patent office will not take much time, or trademark office will not take much time. Just a digital, you compare all digitals, numeric assignment. If any of them is comparable to or similar to it, they will just graphical list will come. Suppose some digital trademark has been filed, you go, software will just compare and throw you some 300 of these images, just as Google will do. Every type a certain name, and it will not only description, it shows some images also. So that will be a remarkable item. So they will not lose innovation, and women force will, I think they will decide it in a very, very balanced way, because IP acts are structured and drafted in a very balanced way. Rights of IPR applicant, rights of the government, and provisions of IP protection by the provisions of infringement suits in the court and all that. And so by understanding this balance, it will be a I mean to say that there will be a more judgmental values, that woman sitting in the R&D lab or an IP office will really make justification that whether the organization should go to the court or not. So this will be a very good step if women are included, and this force is increased in India. The IP rights were great barriers in pandemic recently, but on the other hand, they have created an economy and option to choose. The affordability of IP rights were questioned, but then innovation has provided our country with co-vaccine and Covishield. Otherwise, it was not possible. We would have always complained that no, IP right should be suspended. But then when we are not able to get these vaccines at affordable prices, then then next what? In that such emergent situation, our scientists got together, all data were shared, and result, I mean to say that there were women also, biologists and all, these people just made available their knowledge, and they took the risk of experimentation also. And then these two vaccines will came. I don't deny that these women scientists has made India a Atmanirbhar Bharat as per Honorable Prime Minister. Thank you.
Thank you, sir.
Before can I ask one question from Mr. Naveen Mathur, because he was patent, he's a controller, is present here. As a part of the industry, see, I just want to ask you one simple question. Like, India is a signatory to most of the treaties, patent treaties. We have a patent cooperation treaty, we have a Paris Convention treaty, and a lot of these international filings are also coming to India. And there's a saying, like, when the patent is granted, it is not only granted to a patentee, but when it is granted, it is against the whole world. Now, how you rate the Indian examination system? Like, there was earlier saying the examination system was not very good, that foreign applications are also coming. How you rate the examination system of India when you examine the paper?
Examination system was in consonance with the provisions we were having in Act. The type of applications, the type of innovations we were having. So I don't say that examination was poor previously. There was examination, and there were people who were filing for their invention. Basically, foreign applications were there mostly, and there was no awareness in India about the patents. Patents was thought about as just trademark. So these are very, very different IPs. So people were not aware of what is being checked. And it was the system was I mean to say silent. Rather, all the activities were there. It was examined, it was read by the examiner, it was decided by the controller, but it was not in a what you can say express mode. It was not communicated. It was not visible. As soon as this transformation of digital world, or the digitization was made, and patent office adopted the digitization, and it was more visible to others also. The system improved. System improved in the sense that those files which were lying in a corner of your I mean to say the library or wherever the stock was maintained in a physical file, record room, that were digitized. Some document was not missing, some documents were filed in another application file. So there were a lot of complexities, and examiner was helpless not to find a document. So, but that now, there is no such things now. A more improved, that applicant has to upload everything. So applicant is aware what he has uploaded. The document which he has not uploaded will not be considered by the examiner. And examiner with the click of mouse can see what are all the documents visible with the dates, that on this date document was filed. There was confusion that document has come, but its CBR has not come in physical file. Whether the fees has been deposited or not, the examiner has to send the file back to the fees checking section, that please check if the fees has been filed. Because if fees is not filed, then document cannot be taken on record. So this all distributed system took a lot of time. And day-to-day basis, it was very difficult. But now the integration has taken place, ICT has improved. So all this contribution has made these activities or these efforts which were made by the examiner and officers to find the document. Those efforts were not clearly visible to the applicant. He will say you are granting late patent, but see the difficulty here. We were not having citations, I mean to say the databases and all that in a proper format. How to search tools were not there. Now physical, only physical records were there. You cannot search. So you have to go to your library and find out a document. So then you have to write also that I could not find it in the library, this much of document. So obviously the inventive step, novelty and all that was not so clear. So they were challengeable also. So now if I granted a patent, certainly if it is not up to that standard, my examination or not up to that standard, post-grant opposition will come. No doubt, because examiner is so deficient of its resources. So now the resources are much more comparison to that. And as you talk system, during COVID, we have given maximum output. Sitting at home, we in the work to home, we have given hearings. On agent side is also sitting at working at home, and we are also working at home. Examiner and controllers, despite being suffering from COVID, they have given the hearings, they have taken pain, and I don't think that it is not visible. It is visible if we see the output trend of the patent office. And I think the system is now running good and will every time it needs improvement. I don't deny it. And as the tools improve, suppose use of artificial intelligence will improve the system. That is what today. If my generation is saying, today's generation is saying that this thing is patentable, all right, but if it is if the technology is developing in such a way and artificial intelligence has taken such a route, suppose tomorrow at that time, the previous time, robotics was thought to be something else, not capturable, what it is doing. Now when patents regarding artificial intelligence will be filed, robotics will be at the back seat, prior arts. So that is and what in IT in AI should be granted, should not be granted. I think it's it's a hell of thing, and in the future, industry and patent office and these conglomerates of all scientists and all these things have to decide, trade bodies have to decide what is to be granted, what is not to be granted. Section 3, I think, will need a subsection added to it. Will be a great fight, and if you are more aware, you are more into IPs, you have to clearly, distinctly decide what is to be granted, what is not to be granted. Definition of 3K, definition of 3D, definition of 3F, I fail to understand. If I intervene and AI intervene in this way into the Patent Act, every IP right. So there is a time still, but then system has to update itself. Today, if we say this one, my computer is taking daily updates. I can't work for just opening my computer. I can't just start working. It is taking update. It will take 20 minutes time, 30 minutes time. Previously, it was not there. It was stable. No sooner I open my computer, I can start my work. So that may be the case. In IP region, IP system, what will be obsolete, we do not know.
I think.
And will be a big challenge. And we have to balance out the challenges. And there will be the role of woman. Because kitchen is balanced by woman. So I hope that woman IP awareness will be increased. They will more participate. Thank you.
Thank you. Thank you so much. And now, before inviting our Secretary General, Mr. Sanyal, for the vote of thanks, there is a small felicitation ceremony which we have to do. I request Mr. Goel to kindly give a token of memento to Mr. Naveen Mathur, Joint Controller of Patent and Designs. Goelji, if you can. May I request Mr. Sanyal to kindly give a token of appreciation to Mr. Sudarshan Kumar Bansal. And to Mr. Shravan Kumar Bansal also. Prakashji, Dr. Prakash is there online, but we will be sending you a memento there.
Thank you very much. Thank you.
May I request Goelji to kindly give a token to Dr. Blossom Kocher. Yes, ma'am. Thank you for being with us and giving some practical tips. I mean, your case study, how IP is important. Thank you so much. And now I would like to call upon Mr. Saurabh Sanyal, Secretary General, PhD Chamber. Sir, if you can kindly deliver the vote of thanks. Sir, we are already, we have already, but yes, but Mr. Mathur is here with us, so we will take questions in the panel discussion.
Right. Thank you.
And it's a Callaway set. And the same set is 1,50,000 when you cross the border. So this is the fake story. So it will continue to stay. And if entrepreneurs have to build their IPRs, they have to make brands. They really have to be innovative, make good brands, make digital trademarks and digital IPRs as Dr. Blossom Kocher came out. There is a system of RIFD. The RIFD can generate a digital certificate which can be seen and which can be patented. There are carbon credit certificates being faked, water certificates being faked. So I mean, there's no. These are also innovations. It's a very innovative mind of a startup which creates such things. But then the IPR is needed. It is very essential. One has to really get into it. We have outlived that life. You are the future of India. You are the future prime ministers, presidents of India, and the presidents and CEOs of various companies. So you have to think about innovative solutions, come out with simplistic things of branding, simplistic processes of creating IPRs. With these words, I thank once again all of you. Thank you so much for being here.
Thank you, sir. Thank you, sir. Thank you. Thank you, sir. Thank you so much. Your presence here has really motivated us, and the history which you gave was quite interesting. Thank you. May I request, sir, one, I will not take much of time, just 1 second. May I request Sudarshan ji to kindly give a small memento to our Secretary General, Mr. Saurabh Sanyal ji. So thank you. I know, sir, this is home run, but a small token of appreciation. Yeah. And a small token of appreciation to our Sudarshan ji, kindly a small token for our co-chair Goyal ji. Goyal ji has been always, we always call him, bother him, but he has been always a support in this journey. Thank you so much, sir, for being. Thank you all. We will not be breaking for tea because we have already, gone about time. So tea will be served here. Please join for the panel discussion. 5-minute break and then tea will be served here. Dr. Kumar is here also, sir. If you can kindly join us for the group photograph. Break and then we will be assembling here because we are having a very important session on patents. So please join in 5 minutes.
So welcome, friends, ladies and gentlemen, to this technical session. I think we have had a wonderful session, inaugural session in the morning. I think a lot has been said about the need for bringing more and more women in IPRs. While we knew a lot of the importance of this, but then it has been highlighted again in this morning session. So this session basically we are going to discuss on shaping advancements in technology. Actually, this is a different words. Shaping advancement in technologies means how do we take the advantage of technology by recognizing the technology. So that is the discussion that we are going to have today. How do we shape the technology advancement? How do we, recognize these innovations and advancement in technology? Well, I would say that a lot was mentioned about the need to create more and more awareness amongst the potential innovators and those who have innovated already, particularly the women, innovators. Now, awareness is very important, of course, but awareness of what? See, we know IPRs are very important. Patents and trademarks and geographical indicators, all these copyrights are very, very important. But let us not spend too much of time in creating awareness about the procedures part, because procedures in filing of the IPRs and then procedures in involved in examination and grant of IPRs is one side, which is of course on the side of improvement gradually, as Mr. Mathur also mentioned in the morning. Our more focus should be on creating awareness about how to innovate and how to take advantage of these innovations, how to commercialize these innovations, what kind of facilities are available from the government, and how do we create a culture of innovations and a culture of recognizing these innovations, shaping these innovations. So we have experts, in fact, to talk about this. I will not spend too much of time. We are already starting almost how much? 55 minutes late. So I don't want to delay the closure also. In fact, we should try to close it as per the scheduled time, which is 2 o'clock. So I have 1 hour and 15 minutes. 15 minutes for question answers, because that is also very important. I would expect that probably you have certain queries, because morning also we missed these question answer session. So the net time available is how much? 1 hour. And I have how many experts? 5 experts in this session, and then followed by an international speaker from AIPLA. So how much time we can give? Maybe 10 minutes. 10 minutes each, 6 speakers. So I think 10 minutes is quite fair, very good time. So I will only flag certain issues, I mean, within 1 minute, and then invite my experts, in fact, to speak about. Awareness, of course, we have seen there is a need to create more and more awareness throughout the country. And this program, basically sponsored by United IPRs and organized with the help of PhD Chamber, is basically a step in that direction. Then procedure part, of course, as Mr. Mathur also mentioned, procedures keep evolving and keep changing. Cost is one important aspect. How much is the cost involved? How this cost is being met? Because if you expect innovators to spend money for when they are struggling, in fact, to bring these ideas to the world, and then spend money and time, because time also involves a lot of cost. So that is one important aspect. The time taken in the whole process of starting from zero for recognition of the invention and then getting the final result, that is important. And there are other things, of course, like after the IPR success, you get the patent or copyright or trademark. What next? How do you get the advantage of that? How do you get that particular invention going to the market for commercialization and for really getting the benefits of that invention that you have created, and other things of course related like valuation of the IPRs, and how do you value the IPRs to interact with the community and other business world. So these are some of the issues which I thought would get addressed in our presentations, and if there is anything left out, we will address it through the questions. So we have 5 experts. Ms. S. Kiran is available, of course, with us. And let me also acknowledge the presence of our friends from United IPR, Mr. Sudarshan Kumar Bansal, and Mr. Shravan Kumar Bansal. Thank you. We have 2 experts available on dais, Mr. Satish Kumar and Kiranji. And there are 3 experts besides the international speaker who will be addressing us online. So to begin with, I have been asked to invite Mr. N. Sudhir Kumar, who is the director of ISRO headquarters, to address this technical session. Mr. Sudhir Kumar, over to you, please. Can you hear me? Yeah.
Hope I'm audible.
Yeah. Please go ahead.
Thank you for the gratitude. Thanks for the invitation to address. Unfortunately, I have another commitment at 1:30. That's what I requested to schedule me initially. Pardon me for the excuse of this thing. Okay, as far as space is concerned, the IPR, the India intellectual property protection is very important because it's a very niche area where the innovation is only the way to achieve the things, and the protection of intellectual property is inevitable. Okay, to this.
Mr. Sudhir Kumar, your audio is unstable. Can you please switch off your video so that we can hear you? Hello. Can you hear me, Mr. Kumar?
But of course, I have a couple of points to say in context of the protection of IP. Unless otherwise, we see in the business perspective, unless otherwise there is a
Your audio is unstable, Mr. Kumar. I think your connection is also dropped, it seems. So we'll wait for you to reconnect. Disconnected. So I think we can wait for him to reconnect. In case he's able to reconnect, we'll give him some time later. So meanwhile, can I invite Ms. S. Kiran, who is available with us, physically, and is a very prominent member of this panel. Ms. Kiran is basically a very experienced person in the intellectual property regime, and is a professional with over 5 years of technical experience in patent research analysis, including patentability research, prior arts, technology landscape, and she handles the responsibility of IPR management as the technology officer at the Foundation for Innovation and Technology Transfer, IIT Delhi. I can go on reading further also, but I think IIT Delhi is enough in fact. So over to you, Kiranji.
Thank you so much, and the panel members and everyone, a very good afternoon now. So sir has rightfully addressed the issues in the IP domain, that how much is the cost for a researcher, how much does it affect, and what after filing of an IPR, what should we actually file, how is this evaluated? These were the points that were highlighted by Sir sufficiently enough that I would like to answer some of them. So we all know what these patents, technology, intellectual property, these are the buzzwords in today's scenario. And we know how to define technology as the innovations for giving us a better solutions to the problems that are existing. So what after giving the solutions? If we have a solution to some problem, what does a patent do? It will try to safeguard that solution in a document so that once you take that invention to the market or to the third person, it will protect it from the exploitation of that particular technology. That we can define as an interrelation between a patent and a technology. So they both go hand in hand. We do not need to say patent is different, technology is different. I have a technology, but I will keep it in the public domain. We should not do that. Once an innovator identifies something, comes up with some new invention, he should first go for the IPR protection. So IPR protection, it is not very much difficult term to, as it is very, looks very much new to understand that what is IPR. I don't know how to approach it, but then it is not that very extraordinary thing that we should not go for. So in India also, we have seen many technology-based companies, startups and products that have come up. So it is the technology prowess of India that today we are a reckoned force in the area of vaccination and drug manufacturing. And we all have seen it in the COVID times, how the vaccination drives have taken up. So this is very evident from the, like earlier panelists have also said, the number of filings in the IPR have increased to a very greater extent as compared to previous years. And the same has been being looked at in various areas in Indian universities, institutions. At the institute level also, there have been many developments such as tech-based startups are being involved. Many center of excellences have been coming up. Work in the electric vehicle, EV systems, robotics, all these are coming up. So the technology advancement and patenting are not too much different from each other. So in IIT also, we can say that in previous years, we have more than 150 patent applications, IPRs filings, which it means the research is being generated continuously. It is being grown every minute, every day. It is coming up with a new research. People are coming up with new research. And how prepared are we to protect and safeguard it? That has to be identified. So the future of this, any country will be from now on, the future will depend how technology ready we are, how our technology is growing. So it is important that our patenting system is robust enough to adapt to the changes of the technologies. So even in present scenario, the patent office has made a lot of efforts changing its rules and including new rules and regimes to the scheme and the schemes to promote the IPR filings. Like they have introduced the CRI guidelines few years ago, wherein computer related inventions, how they can be protected in the IPR. They have created a lot of national policies. The Biodiversity Act was there, how the bioresources can be included in the patent, how do we safeguard those? And recent development was reducing the fees of the educational institutions. Being from an academic institutions, I can say that the official fees has been reduced to 80%. That will motivate all the innovators to safeguard their technology more and more. So although many efforts have been taken up by the patent officers at various platforms, but then there are still various efforts, more efforts have to be made in safeguarding as much as possible. I have been reading a recent report by Parliament of India that was presented by the Standing Committee in the Parliament of India, wherein they have tried to review the national IPR policy of 2016, wherein they have addressed some gaps, like Section 3 restricts in the Patent Act, Section 3 restricts various things that are not patentable in our invention. But technology is not growing according to that. Technology is growing to a next level, to a greater extent. So some of the sections that were highlighted in that review were related to section 3B, 3J. So some of the suggestions were quite good, that some sections have to be reworded to be more precise, that it should be better to protect as much as possible rather than restricting it altogether, giving it some platform to broaden the scope of the inventions. Similarly, the sections such as section 3 section, and there are procedural delays, the things that sir was mentioning, procedurals. If we miss a deadline in the Patent Act, for some deadlines there is a provision to overcome those by filing petitions or late fees. But like if we are filing for requests for examinations, there is a huge window of 48 months. People will forget when they last filed the patent applications. So that 48 months can be reduced. So that effort has been made, like 18 months. Now the expedited examination provision is there. And then if we miss the deadline of request for filing examination, that deadline is missed. That case is closed. Merely by not fulfilling a procedural requirement, the abandonment happens. So these things have to be worked on and have to be addressed in the patent system and scenario. And now the CRI guidelines have also to be modified based on the requirement of AI, ML, ICTs, and such technologies, for which like we are moving forward to a modern society which will require all these things, and we need to protect them as much as possible. And we have a huge library of traditional knowledge. So there have been, it was there, traditional knowledge was there, but then there have been innovations in the traditional knowledge also. And our patent regime is also working on it to try to protect as much as, but it should be more inclusive, that I would say, more and more IP generating out of traditional knowledge. The new IP, that is either a product or a process that is being generated, there should be a scope or some guidelines that can help such technologies. So national IPR policies are also in place. I think they can be revisited, and wherever certain, to a certain extent, they are working, but they should be, the awareness should be at the grassroots level. Even the farmer should know what are his rights and what all can he protect. Not only the developed cities, I would say. So what we do at IIT, so I would conclude this this thing in what we do at IIT. We generally seek the inventors' research, what exactly they do. We try to help them, like what exactly is known. We perform the patentability search. We all know that patent requires certain criteria that have to be fulfilled and all. So basic search we do, and then we try to help them. How exactly are they trying to protect it, whether it is a patentable subject matter, whether it is a trademark, or whether it should be a copyright. So we have one of the first IPR policies in place that was drafted in 1994. Further, it was again modified and come into place. We have an IPR cell and technology transfer cell. We approach the industries and then we show them our technologies. So for then commercialization process, and then we try to build the gap between to cover the gap between the academics and the industry, because industry's requirement is totally different, and what the research done in the academic level is a very small scale research. So we need to try to cover those gap. We have to think of a better procedures or formats to reduce that bridge. And the cost, about the cost that sir was mentioning, it was very high, not very high from an Indian perspective, it is very reasonable. From other countries' perspective, it is very reasonable. But then for an Indian perspective, it was still costly affair. Now, after getting the reduction in fees in 2021, it has been very pocket friendly. So as I think initially it used to take 4.5 lakhs for a patent to be granted, only the official fees for to renew it, even including the maintenance and all. But now it is going to take almost around 84,000 for IP filing and the maintenance and prosecution. So there has been an 80% around reduction in the IP. So I close my remarks on this. So I will ask
Thank you, Kiranji. I
Thank
think
you.
very
Thank you so
useful,
much.
very useful inputs. You flagged certain issues. I would suggest that in case these issues can be compiled. Okay. These issues can be compiled. In case you can help us in compiling these issues, what you raised. These are very important issues, so that we can send it to the registrar, the Ministry of Commerce, and request them that these improvements can happen in the procedures as well as in the sections that you quoted. But very nicely, summed up. And I would also say that, in continuation of what I was saying earlier, that what happens post IPR, when you are able to do all that effort. Of course, I can understand you get some subsidy, 80% fee concession, and then help handholding, and then you get the patent or maybe copyright and trademark. The actual work starts after that. So I would suggest, since we have a friend from the government, Mr. Satish Kumar, and he's a friend of our industry and chamber both. So I would suggest that in case we can devise and include, Satish ji, see, after you get the patent, you need to do the market survey. What is the utility of that patent? What is the utility of that invention, or the creativity that you have really achieved? Because if you really say that patent and IPRs are asset, so you should know what is the value of that asset, what is the demand of that asset. So market survey becomes the first thing, because it may be an asset in your mind as well as registrar's mind. Okay, since you have applied, we are giving you the patent or the IPR. But actual feedback will come from the public, from the market, whatever maybe the sample size small, one region, or maybe the country as a whole, but some scheme where this market survey funding should be given. That is first thing. Second thing is, along with this, you need to do the branding of your product. And for that also, in fact, people don't have resources, financial resources. They have to spend money and then do the branding. So for branding also, something should be built in. And of course, nothing better than the commercialization part. That is the last one. If your market survey reveals that the product is in demand, your invention has good takers, so why not commercialize it? And then for commercialization, at least some kind of support. I'm not saying it's always, in lakhs and other things. At least to begin with, some, maybe seed funding, maybe some kind of, soft loan that could be considered under the scheme that probably will surely help and incentivize youngsters, particularly the women, to create more and more innovations and go for getting the assets created through the IPR registrations. So having said that, I am told that Mr. Sudhir Kumar has joined back and is available. So in case you are available, Mr. Sudhir Kumar, can you please?
Yes. I hope
Yeah, please,
this time my
carry on.
connection is proper.
Please carry on. Please carry on.
My apologies, because I normally Zoom will not work with us. That's the reason I try to get it through my mobile.
No, we appreciate. Yeah, please.
Never mind. I think to come to the point, the space technology is a very niche area. That's what I was trying to convince about. Where the space technologies, whatever they're developed by the national space agencies, were quite useful for the industry. When we confront 2 or 3 situations where really the legal experts and attorneys will also put their fingers crossed, especially to give a narrative story or a procedural perspective to that one. One thing is, let us say, when old technologies we have developed, they are no longer innovations, but as a product, because it's a couple of combination of different technologies. When we consider it as a big product, how actually the protection of intellectualness will be ensured by the government agencies? This is one perspective we have. We could not get a perspective answer. Probably, I think when you are seeing a particular product or a particular process which is innovative and which qualifies the basic principles of intellectual property, yes, that's fine. And second thing is the technologies. My straight question is, when you take IPR, even though it shows the intelligent index of an organization or a country, as long as they are not put into the commercial use, and as long as it is only an overhead for the institution, it is only just says, yes, so and so organization has got so many patents. It only numbers. But ultimately, how to commercialize it? When you commercialize it, when you get some, I'm not even telling the revenue part of it as far as government is concerned, but when it is not put into use, it is only just subjected to a paper or subjected to an organization. How actually it will be incentivized? Or maybe just I wanted to show my intellectual property, but at the same time, when it is not able to commercialize, what kind of incentivization will happen? That is the second thing which probably I think attorneys or lawyers, they have to throw some light to encourage such kind of innovations. At the same time, when it is not commercialized, not to spend much on the registration part. The third thing is, let us say this innovative things, government is now looking for S&T departments especially to give many more technologies to the startups or to the MSMEs, so that the country's economy will be developed. So nevertheless of, let us say, the potent production, how such kind of, let us say, startup, you cannot treat a corporate, an MSME and a startup at par. These are all some of the new things which we have to deliberate upon, and government policies have to be brought out, how to intensify. In fact, chair also mentioned the same thing in a different way. Probably the government guidelines and directions, if they are taken in this perspective, probably I think some of the government organizations especially will have a leverage to utilize the patent laws and patent technology transfers agreements, and etc., etc. I hope the panel would address these issues in a befitting way. Probably, I think because of the paucity of my commitments, so that I will stop here. Again, I show my sincere thanks to the United Patrons for giving me the opportunity. Thank you.
Mr. N. Sudhir Kumar, Director ISRO Headquarters, and he has been a very senior executive in the ISRO. Thank you very much. In fact, your inputs are very valuable, and the point that you mentioned, that without commercializing, the patent or the intellectual property remains on paper. I mean, unless you are utilizing the particular invention or the creativity, it has no meaning, and we fully appreciate. The only problem is that we have to facilitate even that process also, the facilitation for the commercialization, or at least the inventor to take it to the market or to the society, so that some way or the other the utility is proven, and then it takes its forward route. So thank you, Mr. Sudhir Kumar. Let me, I think we have, yeah.
Small observation.
Yeah, please do.
And so, hello, sir. I'm S.K. Bansal from right here.
Hi, please.
So regarding the commercialization of the IPR, and the learned speaker from IIT and has mentioned, so commercialization, no doubt, but at what stage should we see it? And Mr. Sudhir Kumar rightly pointed, either before we file it, we should do it, because the filing process takes time, it takes energy, it takes a lot of resources, economics, or after we get the patent, and then we look out for the commercialization, whether it is really worth it. So, sir, I would just suggest there must be some mechanism available, whether from the chambers, whether from the lawyers associations, and from the industry at large, that try to even file, and educational institutions like the facilitators from IIT and so on, that try to even filing for the patent, and if the inventor knows that he has got an invention, which would be a subject matter of a valid patent, at that point of time also some inquiry must be made.
Excellent.
And not just wait for the patent to get and then look out for the commercialization.
Yes.
So I think at both stages it is required. But if it is done at the first hand, after all, so the inventor, if they are ladies, so they would also be spending resources. Many of them may get backed by industry or somebody to finance it. But many of them may not be that lucky.
Absolutely.
They may have to pay 84,000 rupees, as was from the IIT Delhi, we have been pointed out that at least 84,000 rupees the cost will come. That is not as, I mean,
Small money.
Somebody has to pay for it. So I think the commercialization aspect must be looked into, sir, at the stage when we go for it and even post thereafter. So some application of mind on this aspect must be kept. I mean,
Well said, well said.
Yeah.
Thank you.
So Kumar, you would like to respond to this or?
Exactly. So this, what we do in ISRO is incidentally, whether it falls in the procedure gamut or not, the moment we file the patent to our attorney, if the takers are there, we do open a negotiation or discussion for transferring the technology. Because otherwise, if you wait for the patent, we do not know whether it takes 6 months or 1 year. By the time we lose the market. So we incidentally take that stand, but as Dr. Bansal mentioned, probably such kind of provisions should have been there as a part of law or as a part of what you call the mechanism. Thank you.
Mr. Satish Kumar wants to make one observation.
Yes, I would like to add what sir said. So suppose if you have some innovation, so it's always it's a right thing to file your patent and look for the investor who is interested in your technology. So suppose you file your patent application, the kind of technology, kind of invention you have. So you are getting from the date of filing your invention get protected, and during that time, if you find some investor, then you can go for the commercialization. In case you are not getting an investors, you can simply abandon your application, and your invention is still it's not in the public domain, so it is get protected. So your patent filing, your IP strategy should be aligned with your business strategy. If you have some kind of business model, then only the IP right will be successful.
Wonderful. I think this discussion is becoming very interesting now with the participation of our audience also. Shashi Singh ji want to mention probably one observation before I go to the distinguished panelists.
Since you're from ISRO, I was just pointing out about women. How do they play an important role? Because I think ISRO is now giving it out for MSMEs or the micro small sector. So would you have any preference for women to come on board? The second thing I want to point out is because we were talking about need assessment. So are you giving any kind of clues that we could involve more women to manufacture or even innovate something for you where women could come in clusters, because we work with clusters or groups of women all over India. So I think these two, if you could help us with something, we could take it further from there.
Oh, definitely, I agree with you, but technology doesn't have any association exclusively on the gender point of view, but is all the technologies and other things is a culmination of teamwork. In that one, definitely women scientists also will be there. But I can't say that one woman is exclusively responsible for that one, even though the patent, it could be a group, it could be women also a part of the team for representing the patent. But definitely, if some proposals are there from your side to encourage women, especially on a specific subject, we are with you. We will cooperate with you.
Thank you. Thank you very much. Thank you, Mr. Kumar. Thank you.
Thank you.
So let me go back to the scheduled program. We have distinguished Dr. Aruna Tiwari, who is the Assistant Vice President, CPAM, Department of Promotion for Industry and Trade. So I would like to invite her and briefly introducing her. She is PhD in Life Sciences from Patna University and is a registered patent agent. And she received her IP related training at CSIR under the WOSCC scheme of TIFAC. She has an extensive experience of IP of over 12 years while working at ICMR and TIFAC. So very experienced, scientist who is having a cross section of, areas, having worked and experienced. So over to you, Dr. Aruna Tiwari, for your presentation and discussion. Dr. Tiwari, can you hear me? I think आप mute पे हैं.
Yes, I can hear. Just give me a minute. I'm sharing my screen slides.
Okay.
Am I audible?
Yes, please. Please carry on.
Is my PPT?
Yes, visible,
Okay,
visible.
okay,
We
thank
can
you.
see that.
So, since I am from a science background and I will be talking about the overview of the Indian patent scenario shaping advancement in technology, and I would talk about the positive things rather than discussing what needs to be done. Because earlier, when the patent regime was not in place, people used to have solution in the form of product or process, which is protected through patent. But they used to keep it as a secret till they die, and they would not disclose it to the others. But thanks to the patent regime, that the inventor or creator of the product, new product or process in the form of a solution to any difficulty or any problem, it was required to disclose to the government so that the document, a description in a documented form could go on the patent office website, and it would become available to everybody to be read and to work upon it. So I would illustrate the same with one example, and that is very close and very useful also in day-to-day life. Can we think of our life when it was without telephone or mobile phone? Can we think of how people used to communicate in those era, those time when the phone was not in place or mobile was not in place? No, we can. In today's life, we cannot, because once we wake up in the morning, the first thing we go to our mobile phone or smartphone and we scroll whether any new message is in place, any new mail is in place or not. Similarly, before we go to the bed in the night, we again scroll through our mobile phone to check whether any new mail or any LinkedIn message, any Twitter is there, any urgent work is there or not, or any to know the entire world what exactly is going on in the world in the form of internet. So it has become integral part of our life. The mobile phone is, but how difficult the life would be when the patent system was not in place and no mobile phone was there. How people used to communicate. This was the mode how they used to communicate. Two objects made up of either of wood or metal attached with a string to communicate between two persons, and for personal communication this was used till the telegraph came, thanks to again patent system and Graham Bell. Graham Bell in 1871, he made a telegraph which had a facility of sending few words of message from one place to another in a quick mode. But this was not enough, and Graham Bell was working upon it, and he came to this telephone thing. On your left hand side on the screen, you can see a two-piece telephone is there. But the Graham Bell, what he invented, it was a huge apparatus, and it was very not easy to communicate from one place to another, and even there was some limitation. But the patent system was in place in USA, and the document was in place. So somebody read that document, and they were not happy with the telephone apparatus available. So they came up with the dialer phone. Dialer phone, on your right side, it is in a black and white mode. So dialer phone has some facility. They fix this audio and speaker in a one place. So it was easily comfortable to communicate from holding the receiver in one hand and dialing the number wherever you want to dial. But again, there was a problem. If you miss one of the single digit, you need to dial all the numbers time and again. It was again difficult and cumbersome work. So someone who was of thinking mind, and he or she was working upon it, how to make it more user friendly and how to make it more comfortable. This digital phone then came into being, came into place. And I would like to mention one more thing. In 1876, Graham Bell invented telephone, and after 7 years, 4 telephone exchanges were opened in India, in Mumbai, in Kolkata, and other metro cities. So what I was trying to emphasize, that technology is changing at a very fast pace, and it is not only limited to one place in this global period. So you can think of in 1876 even, and it was invented, and within 7 years, telephone exchanges were opened in India. Though internet was not there and communication was not that fast by that time still. And now we are living in the internet era, and everything is a matter of second, and a fraction of second, it goes from one place to other in across the world. So technology is changing on a very fast pace, and we have to look forward to those technologies which could help us to evolve and which could help us in making our life comfortable and better. So again, this phone was not enough for few of the startups or inventors. They went for a they were not liking this fixed connection and communicating with others. They wanted some more privacy or more freedom to roam around. Then this cordless phone and mobile phone came into being in 1990s. It seems this mobile phone was launched in India, and these mobile phones were more than a kg heavier more than a kg, and they used to take 10 to 12 hours of charging for hardly one or couple of hours of talk time. So again, and these are all patented documents which were used in these phones. So again, someone was not happy with the whatever was available in the market and for communication. Then came the smartphone which we are using. Now you can name it and you can have those facilities in our smartphone. You think of internet, it is there. You think of radio, it is there. You think of a music system, you think of camera. Earlier CDMA technology was there. Now GSM technology is in place. 2G, 3G, 5G. I don't know what is in lying in the future. So what I wanted to emphasize is the patent system has made life comfortable and it has helped a humankind so much. And one of the panelists or today second round panel is they were saying that what is the use if it has not been commercialized. Even your patent document has not been commercialized, someone can build upon it and could be helpful and can make it helpful for the humankind. So don't think whatever solution you have come up with always would gain you a monetary refund, though the patenting system or IP system has been made for those benefits only, but still every time you cannot think of monetary benefits would be gained. And if you plan ahead in advance, then you can have monetary benefits also. If you go through market survey before launching your product or before even before thinking of going for R&D and other things, this is my suggestion and my understanding that market pull and market push also matters. So if you are coming with any solution or any new invention which has some market pull, then definitely the inventors would have monetary benefits easily. But if you are pushing something into the market, it would every time it would be difficult. As in the case of telephone, there came pager was also in place. Pager had the facility of sending few words for communication from one place to another, but it was in practice for 5 years or so hardly, because then the smartphone came and smartphone has all the facility of sending SMSs and WhatsApp messages and other facilities. So pager was abolished from the market. So it all depends upon your market skills. So that is also required for gaining a monetary benefit. And beyond that telephone thing, if I see that 3D printing also started in developed countries, and in 3D printing is also known as additive printing, where you have to make a physical model from virtual model, and you can think of how much it is useful in every sector of your life. 3D printing has now become useful, be it food, be it toys. We have at DST, I had received application for 3D printing in jaws, dentures in a couple of years back, and other even buildings can be made through 3D printings and other, and even Mano, one robot made in India, it has been made through 3D printing itself. So 3D, now I am talking about few futuristic technologies which are already patented or applications are being received at India as well. Now, nanotechnology, any technology which is based on where atoms and molecules are of very small size, of nano size, and it is very useful for pharma industry where specific location is being targeted through the medicine or drugs, so that entire body may not get affected by those drugs, and only the specific area or target is being used by those drugs. So, and beyond that, even to remain young and to beat the age, nanotechnology is being used, and of course it will be useful for the human being. Next, I can go to drones. Drones are driverless vehicles, and these are very useful for climate estimation, then natural disaster, where natural disaster is in place and you want to, and it is a difficult terrain to reach or arrive, then drones are very helpful. And beyond that, drones in, if I come back to India, recently the beating retreat ceremony was on 26th 2022, and a startup from IIT Delhi who got finance or funding from DST, they had a drone show where 1,000 drones were displayed in that show, and very magnificent show was being displayed by this startup, and it was acclaimed and even got a prize award from government. So these are some positive aspects of futuristic technologies which started in other countries and then came into India, and India started working upon it. And beyond that, even in the telecom industry, India is users, in terms of users, India is second in the world after China. So telecom industry is developing, and if we want to have some startups in telecom industry, that would definitely flourish. And next technology, futuristic technology, is robotics. Robotics is a multidisciplinary product or area, I can say, where computer engineering, mechanical engineering, electrical engineering, all are put into place, and they are robotics in robots can be made of various kinds. The most well acclaimed or liked by the students are humanoid robots, which act and behave like just like humans. And in India, we have a Kempa robot which wishes you in Hindi and English, which greets you at Bangalore airport. So that use of robot is being well used at the Bangalore airport. And there are other artificial intelligence. When I say artificial intelligence, we can use artificial intelligence just like, or say on similar lines of as human think or work. And this artificial intelligence is generally being used as nowadays we cannot work in a separate area. We have to have some multidisciplinary areas to be worked upon, whether we like or not. So whatever I discuss, everywhere almost artificial intelligence is being used. And by using this artificial intelligence, like GPS of Google is very famous artificial intelligence. And there are so many examples which are very useful for humankind and makes our life comfortable and helps humankind in several ways. And beyond that, we have Hyperloop. We have big data, where big data is raw data is processed and analyzed to arrive at a certain point for again to have some useful information from that big data. Then green technologies, there futuristic technologies, and other technologies we can say Internet of Things. So everywhere internet or software or these are being used. So it seems that now in future we need not to learn languages, Hindi and English and other languages, vernacular languages. We would be requiring to learn computer languages. That is all from my side. And yes, patent regime has given so many positive things to humankind, and they are giving us the impetus to develop upon the technologies which are not even being used or marketed. Thank you from my end. Thank you, sir.
Thank you, Dr. Tiwari. Thank you. I think very useful inputs and very well explained these new innovative technologies. And your observations also are worth noting, in fact, that even if your intellectual property doesn't get commercialized, don't get disheartened. At least you have created something which may be useful for the society or maybe your own personal uses. So this is a different perspective. So we appreciate surely. And now, one online, one physical. So to keep it, like everybody involved. So I would like to invite Mr. Satish Kumar. He is from the ministry, working as an assistant director to the government of India. Presently posted.
Sarah is online for AIPL and she's yeah. Yes, sir.
Before Mr. Satish Kumar continues, we actually have a member of the AIPLA. She's the coordinator for the Women in IP Global Networking Initiative, Dr. Sarah Kosciux Smith. Welcome to the event. So she holds a master's in chemistry and from the University of Oxford and holds a PhD in organic synthesis from University of Southampton. She joined Newburn Ellis in 2011 and is a partner from 2019. Ma'am, thank you so much for joining us, and over to you.
Thank you very much, and thank you for fitting me in. I'm dialing in from Europe today, so different time zone. It's morning here. It's my pleasure to speak with you all today and to see such a fantastic schedule of eminent speakers. So thank you very much to all of the organisers for putting together such a wonderful event. The AIPLA Women in IP World Global Networking event is now in its 15th year, and it's a fixture of AIPLA's global outreach activities. I think this is a wonderful event that brings together IP practitioners from all over the world to have fun, discuss important issues, network, and make new friends. This year's event coincides with World Health Day, so we chose the theme, being happy and healthy in our work. And to my mind, this topic has never been more important. We're emerging from the COVID-19 pandemic, which sadly also brought the world together, but in sadness rather than celebration. I think this experience has given many of us a renewed or increased focus on our own health and that of our colleagues. Both physical and mental health are so important, and for many of us, work is such a major part of our lives. We need to be happy and healthy in our work to achieve our full potential. Despite this year's global networking event being smaller than previous years, today we have people like you meeting across 5 continents. So by attending the event today, you are part of that global community, and we love seeing and hearing what you're doing today. People today are meeting around the world and enjoying, amongst other things, panel discussions on well-being and the use of technology like the talk we just saw, motivational speakers, yoga classes, sleep coaching, mindfulness sessions, flower arranging, golf, and even a virtual safari. I hope that each and every attendee, wherever they are today, leaves their event feeling inspired, more relaxed, or better connected to other IP practitioners. Because it's these things, hobbies, mental attitude, and great colleagues and friends that help us to be happy and healthy in work and life. In my own experience, AIPLA is a fantastic place to make new connections and friends, and new members are always welcomed with open arms. So whether you're a member or not, please know that we would love to see you at a future event and for you to join our online community. We're active on LinkedIn, Facebook, and Twitter, and you don't have to be a member to join those. You'll hear more about that in the video played later today, provided by AIPLA. But I speak on behalf of all the AIPLA Women in IP Law Committee when I say we are absolutely delighted to see you here today to learn about your event, and we hope to connect with you again in the near future. Thank you very much. Have a wonderful time, everyone.
Thank you very much, Dr. Sarah. It was a wonderful appearance, and your observations really motivated everybody. And I am so happy to know that this event is happening, similar events are happening in 5 continents. So it's all the, it becomes very important. And your perception about these IPRs and innovations with regard to ultimate objective of achieving happiness, health, enjoyment, joy. I mean, these are the new perspective which you have brought in to our, whole discussion. So thanks a lot. Thank you very much for participating and coming and talking to us. So thank you.
You're very welcome. Have a wonderful day, everyone.
Excellent. Thank you very much. So nice of you. So let me introduce Mr. Satish Kumar, our guest speaker from the ministry. In fact, I was a bit surprised to, read about his credentials, about his CV. I thought that in the government, when people work, they are journalists. They keep working in, from one department to another for 3 years, then transferred to 3 years. And he has been working in IPR. And I was happy to read that he has specialized qualifications in IPR. He got postgraduate diploma in IPR, postgraduate diploma in marketing and sales, and various World Intellectual Property Organization WIPO certificate program. So who better than him can understand, in fact, what are the issues which really need to be addressed in IPR regime. And it is good that he is available today, and we discuss those issues and the improvements which I suggested. I am sure that he would have noted down, not in pencil, but in his mind, and whenever there is an opportunity to work on RAM program and any other program schemes, he has been part of development of various schemes of the ministry. He's assistant director there and looking after this IPR, whole area. So over to you, Satish Kumar ji. Thank you.
So thank you so much for giving this opportunity, first of all. So sir has, before me, many speaker has raised many issues and emerging areas, especially concentrated on IP commercialization. I also believe that this commercialization part is very important. If you see, around the world, only 5% innovations are that is being commercialized. So there's a huge gap in what we are protecting and what is being marketed. That need to be filled up. Kiran madam has already explained all those areas like about the section 3 of the Patent Act, which is limiting the scope of protection, especially on, nowadays we are getting like artificial intelligence. So whether we are going to protect such kind of invention coming from the AI. And so there are so many things which we need to address. We need to, from the policy making point of view, because I am into that policy making field. The sir has also mentioned about there should be some branding support, seed capital support, and also support for to the helping the innovators so that they can commercialize their inventions. Like especially when I'm visiting so many universities, and what I see like the university professors are there, students, they're working on some inventions, but they are not having idea what to do. They are filing a patent and it gets published, and after that they are not interested in going for the request for the examination, and they are not interested in the actual grant of the patent. So like madam mentioned about they are not going for filing application for the request for the examination. I think there are simple idea like they should get this patent and put on some wall and put in their CV and it should look nice. They are not having any idea like actually how to go for the market. Madam already also mentioned about there is a huge gap between what the industry looking at and what need to be done from the research institution side, especially academic institutions. Like most of the patent being filed through this university ecosystem. Definitely, like especially I'm from MSME, I also face this problem. Like especially talking about MSME, they're small entrepreneurs. They are not having any kind of research and development strategies. They're not having any kind of department which particularly working on that kind of inventions which is required for the market. So there could be kind of solutions. I think I will talk more about the solutions. So there could be solution like there could be, I suggested many times in the university, they should have their proper IP policy so that they can reward their university professors, or they can take the money through the licensing and assignment of these technology from the industry. There should be kind of a joint collaborative R&D kind of thing, so that industry can tell we are looking for these, and universities can develop, these academic people can develop, and ultimate this product being marketed after the protecting. Like the gentleman from the ISRO has already mentioned about the commercialization. The IP rights, it functions only when you are able to enforce it. If something you are not able to enforce it, there is no value of whether what kind of IP you're filing. Suppose the Bisleri, if they're going to enforce, everyone is using this Bisleri bottle. I think Gauraji is here and he's the master of that field. I think we have attended so many sessions. we are at NIMSME. So if the BISLR is going to enforce such kind of IP right, the cost will be more than what is actually getting revenue out of enforcing this IP right. So somewhere I believe whenever you are talking about protecting IP assets, and it should be completely aligned with your business, what kind of business you have, and how you're going to before you're going for the filing of patent, you should have a clear idea how I'm going to commercialize it and how much revenue I'm going to generate it. Whether you're going for the licensing, assigning your technology, or ultimately you're going for the making a product. You should have clear idea, and it should be aligned with your business. Otherwise, there's no use of IP. It's just a certificate, which is your established ownership right, but actually you're not the owner of it. I heard all these issues. After 2016, we got a national IP policy, and the Ministry of MSME is also working continuously on improving our policies. We are also getting feedback, like sir has mentioned, madam has mentioned. So whatever feedback we're receiving, based on that, we are continuously improving our policies. So recently, on the 10th of March, just 1 month back, we had introduced our MSME innovative policy. So I have a small presentation. If it can be on the screen, so it will be easy to understand. So this is a recently launched MSME innovative program. Next slide, please. Can you make a full? Yeah. Next slide. So basically, this is a MSME innovative program. Earlier, we have 3 standalone schemes, like we have incubation, IPR, and design. All these schemes are working separately. So now we have merged, because we feel there should be interoperability between among all these components. So we had merged all these IPR, incubation, design component, and come with this innovative scheme. Next. So these schemes are having these components. So I just skip this. So incubation program, like any person having an idea, now they want to develop some kind of proof of concept. They want to develop some prototype. So they can take the benefit of these schemes, whether you are a innovator, you're a student, industry expert, or maybe anyone you are. You can take the benefit of this scheme. You just, whatever idea you have, you require to choose a particular HI, particular incubator and panel by Ministry of MSME, and then you are eligible for 50 lakh rupees grant from Ministry of MSME to develop that prototype. Next, please. So we are also giving financial assistance to these incubators, that is up to 1 crore to develop some, set up some plant and machinery, so that can be used by these startups. Next slide. So another component is design component. I'm just introducing the key highlights, so that because we have very shortage of time. So design scheme is about MSME, like when you are setting your enterprise and you feel like my product, that unique shape, it requires some kind of design intervention. You want, like if I changing my shape of the product, and that can create some kind of advantageous position in the market to my product. So that here the MSME is required to give their this intention, like they just required to sir, I want to have some design intervention in my product. And we have IAs who are implementing these schemes, like mainly these IAs are IITs, NITs. So they are required to approach to these people, these IAs, and they will work on their product and give their this design. Next. So under this, we are giving subsidies, like the total design project cost will be covering this 40 lakh rupees for these professional design, and for the student design product, we are giving 2.5 lakh. And there is a subsidy amount, like if their micro unit is coming, we are giving 75 lakh rupees. Oh, sorry, 75% of the subsidy. If these small and medium enterprise, we are giving 60%. The maximum limit is restricted to 40 lakh rupees only. Next slide. So this is like a business area which we going to talk. So now we are talking about IPR scheme. So under this IPR scheme, we are trying to create a kind of IP ecosystem for the startup, for the MSME or individual innovator. So anyone is coming to us, we are resolving all their IP needs. So basically what we are doing, we are setting up IP facilitation center across the country. Next slide. So these are IP facilitation center are nodal point of contact. Like you are having any kind of IP query, any kind of IP need, you can approach to the center, and from consultation to providing a kind of advisory, any kind of filing support, and helping you to commercializing your technology. These centers are providing support. So next. So these are the how this kind of services being provided through the IP FCs. So like there are 3 stages of protection. Like firstly, you are just a mere idea and you don't know how to go with this, whether it is protectable, whether I can file an IP, or what are the area I need to explore more. Generally, mostly students are coming to us. They are having some idea of invention, but ultimately they can file more claims in these before filing the patent, and so many things they need to know. So in the pre-protection stage, they are coming to us. We are doing IP searches, doing different kind of prior searches, different kind of analysis. We are giving, and based on that report, we are giving a proper consultation and advisory through these IPFCs. Then the protection stage, where now you're ready, your invention is ready, and now you want to file the IP, you want to protect it. So at this stage, you can approach these centers and get file your application, whether it's a patent, trademark, design, any kind of application you have, you can file through the assistance of these IPFCs. Last stage is the post-protection stage, which is covering the today's topic is about commercialization. So here they are also helping like in the enforcement of their IP, like what are the if whether my company is infringing my competitor's IP, whether I am any competitor infringing my IP. So you required these kind of analysis, these kind of reports. It's not like you simply file your IP and it will be protected. No, somewhere around the world, or maybe some places someone can infringe your IP rights. So it's very important. So they are doing this enforcement part. They are continuously working on their IPs, how they are monitoring their IP assets, and also doing evaluation support and helping them technology transfer and commercialization. So these kind of support being provided, like any kind of IP you registered, now you're commercializing, you're going for the market, you can take the assistance of these IPFCs and they will help you in commercialization. Next slide, please. So this is about financial support. So we are giving 1 crore rupees grantee net for setting up these IPFCs. So generally all the organizations except companies, limited companies, we are not giving them to this IPFC, but other organizations like government organization, semi-government, autonomous bodies, chambers, industrial associations, universities, all these are welcome to set up these IP facilitation center. So we are giving 1 crore grant for the 3 years, that is the project period. That can be further continue after the completion of the project. Apart from that, like there is a huge transaction cost. When you're registering your IP, some cost is involved. So we are also giving reimbursement for all the costs, all the expenditure incurred on your registering IP. So these are the figures. Like if you file any foreign patent, so for foreign registered patent, we are giving up to rupees 5 lakh. Then if any Indian patent you have, we are giving 1 lakh rupees. For GI registration, we are giving 2 lakh rupees. For design registration, we are giving 15,000 rupees per application. And for trademark registration, 10,000 rupees per application we are giving. So these are the amount actually which cost. Now it is costing less as lots of subsidies being provided by patent office, like 80% subsidy. Madam has already mentioned about patent filing in the design also, and trademark also. There's 50% subsidy. So these are the and now we have also a dedicated portal. So anyone who want to get more information, they want to apply for reimbursement, they can visit this portal, innovative.msme.gov.in. And on that portal, you will have all the information. Everything is there, and that can be used. Next slide. So we are also running some industrial, awareness campaign. Like I'm here personally explaining the scheme, but otherwise we have different IES implementing agencies and our subordinate field institute. They are also disseminating this information about our scheme and providing and this information about these schemes and what we are doing. So next slide. So this is about a seed capital part, which sir has mentioned. So any beneficiary who has taken any benefit under all these 3 schemes, whether it's a design, IPR, or incubation support, like your idea being supported by Ministry of MSME, you have taken a design support from Ministry of MSME, you have filed your IP. So all those beneficiaries are also eligible to take the seed capital support, which is mentioned here, 1 crore rupees. So up to 1 crore rupees will be given from the Ministry of MSME side, which is in the form of equity. So we are in talks with we are in the signing MOU with the SIDBI, and SIDBI will manage this. So this seed capital support is also here from our side, which was not in earlier scheme. So sir, feedback we have already taken, and incorporated in our scheme guidelines. Next slide. So like this is small presentation about the scheme. So if you visit our website, On the portal, you will have more information and all detailed guidelines are there. And I hope this will help you if you are looking for any kind of support provided Ministry of MSME. So thank you so much. If you have any question, please feel free to ask.
Thank you very much. I think it was a very exhaustive and very precise presentation. Clearly, giving you the information and what are the areas where one can really take the advantage of the ministry schemes, this innovative schemes which has been launched. It was launched, I think, 10th of March only. We attended that program. Minister launched that program. So some of the things have already been taken into consideration. Thank you, Satish Kumarji. And the others also, I hope you would surely take them up. So one that you mentioned, IP policy, formulation of IP policy by the universities and technology institutions. I think that is a key, in fact, to development of this culture amongst the students. So you can incorporate maybe some kind of funding for development of IP policy also by the universities and colleges, because they have to spend money and somebody has to really do that policy. Because why I am saying is that some institutions, universities, Kanchanji approached us, PhD chamber, that we should develop their policy and give it to them. Naturally, it involves some kind of.
Actually, many ministries are also helping these universities in developing policy, like TIFED and DST. They are also supporting universities to have IP policy.
Yes.
So they can approach them also, and from our side, IPFCs are also being approached.
Yes.
So many IPFCs have developed these IP policies for many universities.
So is there any uniform such policy across educational institutions?
So that is being decided with a consultation with this university, like whether they want to give IP rights, to their innovators, university professors. So it's this university. Totally
We have
depends
been
on
dealing with some educational institutions, for example, the Banaras University and so on. There is so much policy also they have, of course. It is for lawyers to find ways out for them, so some consistency must also be there. Madam, what do you say?
It should be in line with the national IPR policy. Every institution can have its own IP policy, but it should be in line with the national. It should not be deviating from the national policy.
Shravanji wants to make some of.
See, I should congratulate Mr. Satish for the wonderful presentation and something very insight. Like, you have been developing the IPR implementation, advising part. See, all these things are happening. That is really remarkable, because see, what happens is, like the IPR work internationally also, and also in India, like, we are at par with the international system. Everybody knows, especially on the patents part and the designs part, the first to file. See the position in the first to file. Unless you file it, you lose your priority. That is the position, and you lose the novelty part also. So many times it happens, that, the person basically, will all the labor and skill, develop something. And by the time, in the meantime, he, out of ignorance, he publishes it. And by the time he comes to us, that it is already in the public domain and he loses the right. So this is something very remarkable, like, before filing, see before filing, before making it to a public domain, in case, like, you advise somebody, okay, this is the invention, this is the inventive step, and then, to file it, first of all, you adjudicate yourself, like, there's definitely some invention. You have a data available, like, whether this is actually the invention or not, or it is already in the public domain, what is the likelihood of the acceptance of the application, and what will be the acceptability in the market. See, the position is before you do all this prior, like, in legal term, we always say it as a freedom to operate, a freedom to do business. So basically you advise on that particular part. So in case that is done, because by the time they approach is like our law firm, like, many of them, they come us and we say that, no, it is not applicable. No, it cannot be filed, and your application will be rejected. Because today, if you file some patent application, you protect some IPR, so much of investment you are going to do, that's the position, just see that. Because naturally you will be propagating, you will be disclosing, you will be approaching various persons, and then for the purpose of licensing or assigning, and by the time, suppose some assignment or some license fructifies, and that point of time you come to know, no, it was not patentable at all. So then, it's such a mental harassment. And this is also the reason why the Indian law also is at par with the international system, like, the treaties, like Patent Cooperation Treaty, because these rights are territorial. These rights are territorial in nature. Like, if you have a patent in India or the design in India, that will be only protected in India. So this is the reason why the treaties are there. Like, simultaneously, you can file an application outside. We have a Paris Convention Treaty where the same priority date within 12 months, you can file the application within the member country. So that suppose tomorrow you have a licensee, you get a licensee in UK, you have a licensee in US, but you don't have a patent protection there, but you have a patent protection in India. So within 12 months time, with the same date of Indian date, you can also file there, so you can have a license export. So what I can basically tell you that Indian law is at par. See, the position is with the international law. It is only that, the way out should be there, like your guiding, that is really remarkable. I was not knowing that, the MSME, they have been doing so much of work. So I should really congratulate you for this, a remarkable achievement. And I think, MSME and the Satish Kumar really needs an applause again. See, this is a wonderful job.
Thank you, Shravanji. Thank you very much. And see, as per the scheduled time given to me, I am left with only 3 minutes.
Can I have a question?
But I see after this, there is a lunch time from 2 to 3 lunch break is 2 to 3, which I feel is very luxurious, 1 hour lunch. So if you all agree, I can take 10 to 15 minutes from there so that we can have an expert available, to talk about, and then some questions if available. Okay. So with your permission. Thank you.
So the 10 minutes will start before lunch or after lunch?
That depends. So I am now inviting Dr. Prakash Ambalkar, who spoke to us in the morning also, I think in the inaugural session.
Am I audible, sir?
Yes, please go ahead. Yes.
Yes, sir. Thank you very much. I will dwell upon, first of all, I would say that on IPR application part. First of all, I thank you, PHDCCI United Overseas Patent Firm, New Delhi. I am Dr. Prakash Ambalkar. I am an agricultural engineer, but in true sense, I am a biological engineer, having 33 years of work experience. First of all, I would say that our national goals of agriculture are poverty alleviation, food security, and then increase in export of agro produce. To attain these goals in time-bound manner, our objective therefore becomes to make the best technologies available to our farmers so that they can adopt them. As we know that presently 70% of our population and our 45% of labor force is dependent on agriculture. Obviously, our production should match the demand both from qualitative and quantitative perspective, and also cost of cultivation should significantly be reduced. And since our quantitative production in year 2021-22 was estimated to be 316 million tons. However, with intervention and adaptation of promising technologies, we are capable to reach up to 450 million tons, perhaps on an early date, if everything goes well. Here we are capable to feed the world also for technology, and that is possible through technology upgradation, since the IPR regime is new to agriculture sector and hardly 1 to 2% patents were granted in this sector in India. ICR has developed innovative and improved technologies under well-organized IPR regime. ICR has also made tremendous potential efforts for these technologies to transfer through public-private partnership mode. Once implementation is further geared up, then there would be perceptible change and further quantum jump would definitely be observed. However, there are constraints too, which are, I would like to narrate point out them here. The advanced IP enabled digitized technologies in agriculture, which have been recently introduced also, and they are being adopted in a very rather fast manner. It is coming up, like laser land leveler, drones, robotics, precision farming using IoT and remote sensing data, predictive pest management, real-time yield forecasting, rotavators, mulchers, raised bed planters, broadbed farmers cum seeders, advanced planters specific to crops, drip cum mulch laying machines, harvesters with SMS, straw reaper, baler, sugarcane harvester, hydraulic trailer, and conservation agriculture technology specific to climate smart agriculture, and etc. These things need further adaptation actually. These technologies may be further improved with more intellectual input on continuous access of patented technology, information, and more R&D on them. So industry should seek more access to technological advancement and innovation, which would be cost effective, time effective, and work effective. So their reliability and quality should also be assured through consistent performance check. And so their performance check is also required to be appraised. And then use of another part is use of renewable energy such as solar, biomass gasification, and biofuel, particularly ethanol production, should be further taken care of with more R&D efforts and patented technologies insights. There should be these should be harnessed by MSME sectors in particular. One important point I would like to underline here, that renewable energy sector has unlimited potential for cost reduction and also for management of waste. And the plastic waste is also included in that. Irrigation, further we come to irrigation and water management. Also the key segment wherein up to 90% water use efficiency can be ensured through subsurface irrigation system, which include drip, mulching, micro sprinkler, etc. Effective liquid fertilizer, nano fertilizer, and biofertilizer, they can slowly replace the urea application, because a lot of foreign exchequer is we invest on that by importing these fertilizers. Then another part is our pesticides, which are very hazardous from the health point of view. Then their potential to be further realized and customized to. They require to be customized as well. Now here one important point is that out of total 329 million hectare geographical area of the country, 143 million hectare is net cultivable presently. But 265 million hectare has biogenic potential. However, out of that 190 million hectare is drought prone. So definitely drip and mulching has an enormous potential where we can increase our production. And here we can also get the crops which demand more water, like paddy and sugarcane also, through mulching and drip. So far these things have not yet been introduced because of lacking of awareness. So we have a very good machine like drip cum mulch laying machine, which needs to be utilized at higher scale, and this should get momentum also, so that we can save 40 to 70% of water, because the biogenic capacity of the land we cannot harness unless we provide we work on the water saving schemes. So further we can also allot it that many bring under a cultivation of oilseed we require, pulses we require, we need to augment its area, horticulture crops we require. All these things if we have, then definitely we can feed the world. Now there have been patented processing technologies also, and here we are very poor, because we are hardly patenting, not more in the double digits, but other countries have even processing their products to the 70 to 90%. So here we have a lot of scope to, from the industry point of view, to harness this potential. And here ready to eat snacks, cooked meat, smoked fish, desserts, sandwiches, cheese, and millet preparation have become generic, and export potential in labor surplus India. You can utilize our labors for the startups, and we can export these things. Agriculture exports, if properly supported by infrastructure, in institutional backup, packaging, and freight transport. We also require cold chain supply, like we can say that refrigerated wagon and cold storage and frozen storage we require at a large scale, so that internal production system can boost the agriculture export as well as farmers' income. Some export bottlenecks, such as problems in market access, non-tariff barriers, and sanitary and phytosanitary issues, cold chain supply, as I already stated, need to be resolved proactively under PPP mode. So thanks to the government initiative of one district, one product, ODOP scheme, in each district can specialize in one export oriented produce based on local agroecologies with crop diversification, etc., as a dire need of the hour if we want to strengthen our economy at a fast rate, because it's a primary sector of the economy. Then we go for the way forward, hence would be to have intermittent workshops, conferences and webinars, etc., to be organized with research institutions, MSME officials, industry sectors, and also with export houses and with other stakeholders for strengthening our forward and backward linkages. If we do all these things, definitely we can transcend all other even developed world, I say. These would enable market access demand at domestic, national, global level. Here more R&D efforts are also required, and these are all promising technologies. And definitely we have a big strength that our labor, ample of labor is available. We can do service. We can also go for faster transport and have a access of the market, because production wise our land is quite capable. We are second to US in our cultivable area asset, which where we cultivation is possible. So these all assets we need to exploit for the best of our all economical and social activities for further gearing up and momentum.
Thank you.
Thank you very much, sir.
Thank you very much. Thank you, Dr. Ambalkar. Very practical inputs, in fact, very useful information. In fact, one area which I would like to highlight is the new technologies which have been developed, which Dr. Ambalkar mentioned, by the ICAR, Indian Council of Agriculture Research. And these technologies are available, as he mentioned, for commercialization and for taking it forward under the public-private partnership mode. That is what I understand, if I am not wrong. Yes, so if you are interested, any of you can surely get in touch with Dr. Ambalkar or maybe ICAR and see which are the technologies which really you can, take them forward for implementation, commercialization in the areas where they are suitable. Of course, I don't know whether they are applicable for urban areas also, because these are agricultural innovations which have been carried out. I'm sure that it would be containing food processing sector also. So maybe you can look at that, and if you find something is relevant, you can surely take advantage of that. So we come to the close of this presentations. We have 5 minutes left as per our agreement. So in case you have any questions, so the floor is open. Thank you.
Sir, I would like to speak here one point.
Yeah, please.
That in semi-urban areas, particularly, there is a lot of potential for exploiting these technologies assets. And what happens now, people, they don't want to go in rural areas to work. So in semi-urban areas, or even some of the startups can be actually established in urban areas too. But fortunate part would be from suburban areas, because the transport cost will be reduced in case if we establish agro startups, agro enterprises in suburban areas. So, and because we don't have a big number of service centers also. So there is a skill development scope, and we certainly exploit for the benefit of our rural youths. So they don't want to come to urban areas for the search of jobs.
No, they are very interested. Everybody wants to go to rural areas now. There is plenty of economy in rural areas. Urban area is saturated now. Urban area, there is so much of competition. People would like to go to semi-urban, urban areas, periphery of the cities, so that really they can get good markets, because markets are available there. So while your suggestions are most welcome, of course, people would surely like to have the benefit of these technologies for the urban areas also. But they are interested, in fact, for I meet a lot of youngsters who really want to do work in the rural areas. They say it's a virgin field and we want to really work there and get, get established our enterprises. So thank you, Dr. Ambalkar. Thank
you, sir. Thank you
very much for your practical inputs. And we can take some questions in case there is any question. So one question, 1 minute. half minute asking and half minute answer, not more than that. Okay, please.
I'll try to be as concise as possible, sir.
Yeah.
Satishji, one question for you regarding the MSME scheme that you've shared in your presentation. So a couple of points which on which you can perhaps give some clarity. One is with respect to the grant which is available. Is it comprising only of the official fees, or it also covers the professional fees, if any? Because, for instance, for trademarks, if the reimbursement is 10,000, so I believe for an individual MSME or a startup, it's 4,500 as the official fees. So in addition to that, it is 5,500, or is it the total fees? Does it?
So it's covering entire fees, like the professional fees as well as government.
The entire fees. And a second part of it is whether it is subject to registration, or is it based on an application that it is granted?
No, it's not based on filing. It's based on after grant only we are reimbursing.
Only for successful
So
registrations.
filing up to grant period, whatever expenses incurred, we are reimbursing.
Another part of this is whether it is available only to MSMEs or also startups, because as an entity, I have the option of either registering as a startup or as an MSME.
They require to register an MSME, so it's like now it's very simple. Like MSME registration available online. They just require to visit our website, and online Udyam registration there, and within a couple of minutes they will get their Udyam registration.
Wonderful.
You can register both also. You can register as a startup as well as Udyam registration.
Mostly people are earlier they were startup, and now they want to have this MSME registration. Also, they also register and take the benefits.
Take the benefits of MSMEs as well. And is it a centralized scheme that this is available for everyone throughout the country, or is it state-run schemes which are there on
central sector scheme, so it's available
throughout the country to all the entrepreneurs? Thank you very much for the clarification. Thank you.
Any other question? Dr. Ambalkar is available.
There was one question for you, sir.
Yeah, please.
This was regarding jugaad. Jugaad is something which is very frugal in the rural areas. So is that is that patentable, or are those kind of innovations being commercialized by you or taken up further for technology development? They are mostly for agriculture-based products.
I would actually know what happens. No, for patenting any technology, actually it should be non-obvious, because if something is obvious, that cannot be patented. So that definitely whatever we do, that jugaad should not be obvious one. So anybody, in case if apply that particular idea, then definitely that will be actually cancelled from the patent office, because it's a obvious thing, and it doesn't actually apply for innovative sort of things. So there is no innovation as such. But when something comes out which is exactly has some sort of change in the mechanism, which brings some effectiveness, some efficiency sort of things in the mechanism of production system, definitely that is patentable.
I can take one more question at the end, if there is any. Oh, great.
Perfect timing.
You said, is there any financial support for enforcing? Because in the GI clusters, a lot of infringements have happened. You know about how saris have been infringed, and Kota Doria was infringed by a lot of imported stuff came in the name of Maheshwari and Kota Doria and all. So can they, if they go into court, is there an enforcement kind of a little finance, because advocates and all take a lot of money, legal money. So is there a provision?
Directly, there is no support. There is a kind of professional assistance they can take from the IPFCs which have been set up, so they can legally advise so that situation could not arise, in future. So whenever they have filed the patent, they can how to maintain and how to check these kind of things. So from these advisory and consultation point of view, they can approach to the IPFC, but the legal charges, legal fees, because ultimately it's the decision of the owner of that property. They have to be bear these expenses, all the legal charges.
Legal
So
charges is the legal aid also. Now. So it's not that advocates charge heavy, but if somebody has faces some difficulty, there's a legal aid also available.
See, why I was saying was because just now, recently, Sabyasachi, there was this whole thing about, the blue, the indigo, etc., being infringed upon by, and they're all agriculture people, they're all small block printers, etc. The whole design was copied by designers. So when large companies like that come in, how do these people really protect themselves? I'm talking about the very, very small people who are in clusters.
Whatever protection and enforcement that has to be effected has to be done within the four corners of the act. So whatever remedy they have to avail of, whether passing off, infringement, falsification, criminal, civil, whatever, has to be done within the four corners of the act. Whether he's a block, a small artisan, or he's a big MNC, whoever. Now, regarding the legal costs, now if there is a person who thinks that he is unable to pay, the legal aid are there. Almost all courts have it. The Delhi High Court has it, even the district court has it. And even regarding the court fee, which many times can be too much. For example, in Delhi, if you have to file a commercial suit, which is valued at 2 CR minimum above, the court fee payable is something like around 2 lakh rupees. This is just an example. It's ad valorem. So if you claim 3 crores, it goes up. So even if somebody wants a concession, then he can also sue. He can go to the under the CPC. There are some provisions available. So it is not that the law is blind on this subject.
see, may I add on in case Sudarshan can finish? See, this is the reason why, under the Act, the rights of authors, rights of inventors are protected. See, and these are made like copyright law and all those, they are made cognizable offenses. See, now suppose I am an author, I am an inventor, and I have created something. Now my rights are infringed. Now I need not go to the court, I can go to a local police station. See, the position is, it is not that everything will happen in the court. See, the position is like they can enforce their rights in a very economical manner. It is just like there are a number of permutation combinations which are available. They can go to the high court for high damages. They can go to the district court. They can even go to a police station. There are district investigating units. There are economic cells which are available. But this is the reason why economic offenses are cognizable nature. Now, suppose there's an author who designed something, and come tomorrow a big multinational company, he comes and copies those. So the rights of authors are there. They can always enforce their right in a best for economical way. Even there are some cases where the authors have come forward, they have taken action. Multinational would be engaging battery of lawyers. But the court says that suppose if you are a big company, why don't you purchase it? See, the position is, but we will not permit you to copy. See, they don't become a right to copy only because of the strength of their monetary aspect. See, that does not, law is very well settled. Like in the Patents Act, we have the rights of inventors protected and the copyright rights of authors are protected. So we have the law also in that particular aspect.
So thank you very much. I think you have been a wonderful audience. We won't take any more questions because the time is already exceeded. So I think we break for lunch. And the next session, yeah. You announce the next session.
Next session, but before that, there is a small felicitation for all of our esteemed guests. So may I request Shravanji to kindly do honors for us and request you to kindly visit a small session to the chair of the session, Dr. S.P. Kumar. Thank you, sir, for sharing the session so well and thank you so much. You have brought some very important points which we would like to take up. Shravanji, if you can please stand with us. To Mr. Satish Kumarji, thank you, Satishji. It is always a pleasure having you. And of course, PhD IPFC is being supported by Ministry of MSME, and we have been working very closely with them in promoting IP awareness, not only here in New Delhi, but in very small clusters and small places where
people, they don't know what about, rightly said, they don't know what patent is and what trademark is. And thank you so much for being a support. And yeah. So now I will request Sudarshan ji to kindly do that. Yeah. And I'm also thankful to Mr. N. Sudhir Kumar, Director ISRO. We will be sending your mementos by courier, and to Dr. Prakash Ambalkar ji. Thank you so much for joining in this important session, and look forward to have you in future also. So now we will be breaking for lunch. Lunch is there outside. Please have lunch, and please.
To Dr. Tiwari also.
Yes, I'm so sorry, I missed it. Thank you so much, Dr. Aruna Tiwari ji. She is Assistant VP CPAM. Thank you so much. We will be sending you the token of appreciation by courier. Exact 3 o'clock we will be joining here, so that we can cope up with the time we have exceeded. Thank you so much.
Welcome everyone. Now we are heading into the last session for the day. This is a panel discussion on the topic patents and industry perspective. We'll cover IP from the industry perspective now. And in this panel, we have 5 distinguished speakers. And theme being the women in IP, we have 3 women who will be representing here and sharing their perspective from the point of view of the industries and their experience as an IP practitioner. And then we have 2 gentlemen. I'll start with introduction of Mr. Neeraj Jindal first. He's a chemical engineer from Manipal Institute of Technology, and he possesses an MBA from SP Jain Institute of Management, Mumbai. He's responsible for new projects and product development for the company Safex. Over the past 10 years, Safex has evolved into one of the most recognized names in the agrochemical sector, where Mr. Jindal has played a pivotal role in marketing and also providing solutions towards an integrated economy with its acquisition of Shogun Organics Limited and Shogun Life Sciences Limited. He's an office bearer and active member of industry body HPMA, which is Hindustan Pesticides Manufacturers Association, which is a leading association of pesticides manufacturers, also taking up the cause of creating IP awareness in the industry. So with that mission, we welcome you, Neeraj sir, on the panel today. Then we have with us Mrs. Surbhi Agarwal. She's an IP practitioner herself and the founder of the School of Legal Education. Welcome, Surbhi, on the panel today. And then we have Akansha Sharma, who's the head legal EN projects, again, an IP practitioner and also an eminent industry expert. We welcome Akansha on the board today. And then we have Mrs. Taranum Khan, who's a senior patent associate at United IPR, and she's also a registered patent agent. So Taranum ji, welcome on board. And another venture, trademarkclick.com, which is spearheaded by another women in IP. And Mr. Vasant Chandra is representing on their behalf today. He's the head of operations and product, trademarkclick.com. Welcome, Vasant. Taranum, I'll be giving a detailed profile of yours before you take over. And with this industry perspective on IP, I would like to invite first Neeraj ji to start his presentation. So please, over to you.
Good evening. I'm very honored here to be invited to give my thoughts on industry perspective from on IPR. Although I'm here in the middle of so many IP practitioners that anything I would say is just showing light to sun, but still, since it is industry perspective, I'll do share my experiences. I'll start with the importance of IPR and patents in particular. All are IP professionals here, so I'll just say that yes, it is very important these days to be very much present in IPR, be it trademarks, designs, or patents. If you are running your own business, it is one of the very important tools that the system provides you to safeguard your very recognized names or very important researches or designs that is giving you that competitive edge in the market. Also, the same IPR being recognized globally through PCT, it also helps you to venture into foreign markets, and especially with stiff competition from countries like China, it gives you an edge that if you have a global patent, you can get into those markets and be assured, because IP has now matured globally and it is a recognized practice, and people do respect, your customers do respect your IP rights. At the same time, not going too deep into IPR, I'll also, from an industry perspective and my last 10, 15 years of experience in HPMA in particular, where we have taken up the cause of industry awareness, awareness of our fellow industry peers on IPR. I'll share some of the experiences there. Now, I would say that the industry awareness, especially in MSME sector, is definitely increasing, but still it is not enough. I have seen so many cases where a company is running for 20 years, 30 years, and then comes up with a problem that there is another company launched 2 years, 3 years back, and they are having the same trade names. And rather the new company is having the IPR for it and the old company doesn't have it. Also, a person doesn't know what patents is. By person, I mean a business owner. And he comes to know only when he gets a notice of being sued by someone whose IPR he is knowingly or unknowingly infringing. And not one, but I have seen many such cases. And that is the time when he goes to the first lawyer he knows or he gets recommended and he is being advised. And more often, he has already got an injunction against himself by that time. So I would say it is now is the time that the technology has its own challenges and benefits. Benefits everyone knows, so I will not go into that. But challenges, the ways things get, the ways businesses are evolving, the challenges are also evolving in the same way. Now, for any person who is running his own business, it has become very important to have IPR cognizance. It is more like an industry, business intelligence tool. What is happening in the industry? What should be taken care of if knowingly or unknowingly I am infringing someone's IPR? And if somebody is filing a patent or a design application or a trade name, which may in future, jeopardize my business interests. So both ways, because 15 years back when I came in the business, I was asked, being a chemical engineer, do you own any patents? So I used to say it is not our job. We are an MSME end of the day. We are more interested in our sales and how we can increase that 10%, 20% every year. That is our job. Now I cannot say that anymore, even if I am an MSME or I may have grown, because there are so many applications being filed by startups. So I can say that we are witnessing unprecedented numbers in IP applications. The size of company doesn't matter anymore. And it is our job to keep an eye on what is happening around. And if you don't catch up, I think there will be severe consequences in every industry. I can definitely vouch for that in my industry. The third thing and that I would like to touch upon is patents in particular are a matter of are a product of technology, technological advancements end of the day. So technology is the heart of these issues. And I was having a very healthy discussion in the lunch session that the evaluation process of these applications is not as stringent or as wholesome as it should have been. And when we talk, we always get to get many answers out of a discussion, and there could be many possible ways out as we got to, as we discussed, to get out of this problem, because you cannot expect any patent controller or a board to be as industry knowledgeable as the industry itself is. So there could be a joint participation with the industry or the governing bodies of those industry who do have that knowledge, and for whom who could really comment very meaningfully on the relevance of, if it is really a very novel and if it's a really a very novel invention or not, or it is something very ordinary for a person in that industry. So that evaluation process must be more stringent and efficient. By efficient, I also mean in terms of time. I have seen patent applications not being decided in even 10 years. And the patentee or the applicant is already enjoying the benefits by telling things in the industry that I have applied for this patent, I will get it granted, and there will be repercussions against you. So these are the issues. If the thing is getting granted soon, if the decision is faster, the position is settled earlier, and everyone knows what to do and what their rights are. So these are my very limited perspectives from industry point of view, and I'll leave it.
Thank you, sir. These are limited but very valuable valuable feedback that you've shared. Sir, I've just summed up your feedback. You mentioned firstly about the global patent, which means a right holder can secure his rights beyond Indian territory also by filing a PCT application or through patent corporation in the concerned countries within the timeline prescribed. So today I'm not only I'm not confining my rights only to the Indian territory. If there's a timeline which I'm following, within that timeline, if I can go up overseas, and I must have some territories of interest where I have business or where I potentially see my business, I can file, and I must file applications in those countries as well. So that's a point well taken, sir. Then you mentioned about the awareness in the MSME, issues on trade names. A similar issue was also flagged in the first session by Mrs. Blossom Kocher. She also mentioned the same issue where IP awareness from the industry perspective is more of a reactive step. So when someone sues you, when someone sends a legal notice to you, that is when you are sensitized on protecting your IP. So rather than having a reactive step, we are propagating and sensitizing on IP awareness because you want it to be a proactive step rather than being a reactive step. So at the very first instance, when you are formulating a strategy, as you rightly mentioned, sir, people are focusing on the marketing and sales because that is where you can see immediate results. And IP is an investment. It's just like your medical insurance or LIC, where you're just putting in funds, but you know that someday it will come very handy to you. So it is a safeguard. IP protects you and also gives you a tool for enforcement. So it's a double benefit that you're getting. You are protecting someone else to sue you, and you're also having a sword in your hand. So it's both a shield and a sword, I would say. So that is something that the MSMEs and startups must consider. And your last concern regarding a more effective and more stringent evaluation of patents, of course, that is a prerogative of the Controller General of Patents and Trademarks, and that is something which we have evolved over a period of time. Sir had mentioned, the Learned Joint Controller in the first session had mentioned that there were difficulties earlier because of the non-digitization of documentation. It was difficult to find prior art searches, and no matter how much experts you are on the subject, unless you have adequate resources at your disposal, you are not able to find the relevant searches which will assist you in finding the objections. So things have streamlined now, and we are hoping that we continue to get better in this regime, and with the kind of digitization that IP India has taken, I'm sure we are heading in the right direction on that perspective. Thank you.
So one question I can ask, because fortunately we have today from the industry representative also, and fortunately we also have the joint controller of patents also with us. See, one of the concerns normally the industry faces, especially in the case of agrochemicals, like, digitization very well, anticipation, you can always see that. But the synergy part is definitely there, because especially what the problems are coming, the industry facing agrochemicals is the combination patents. The two molecules are combined, two formulations are combined, and in one particular document, see, one may not find anticipation. One document may not be found. And normally we see in the patent applications, the data, actually the experiments are missing to show the energy, show the synergy part, because we always talk about efficacy, inventive step, all these aspects, non-obvious, and all those aspects we normally see. Now the question is anticipation may be very difficult sometimes. So normally, see, we have seen, like, this is something, we also made a representation on behalf of the industry, that there were certain chemicals, the combination patent which were rejected. But then the department is accepting those combinations, different combinations to a different patent offices, by different patent offices. So normally the uniformity is not there. So this is something, a matter of concern. For example, the Delhi office is rejecting some combination patent application, but we see Bombay office is accepting those. And those also, naturally, don't we feel that there should be a more threshold, like, examination in these type of cases, where two molecules or two combination, two chemicals are known, they're just admixture and just making out no synergy. So the examination system should be more stringent in those particular cases, threshold, when there are repeated cases like this. So this is a concern. My question is both, part of the industry and also to the joint controller.
It is true that when the application is based on sometimes on data only, and applicant talks about the synergy. Now, to see the synergetic effect, the background knowledge and what way the applicant has come to the patent office, the written document, the specification he has written, that is only means for a examiner to understand in that period of time what the applicant is telling to him by the way of description and specifications and the drawings, and he gives its experimentation data also. So if the citations are in such a, certain citations are found which are just attracting you to the description which has been given. Now the remaining part is data. This interpretation of data or by the examiner, whatever has been told by the applicant is written right, but how he correlates, how he understands, and what has been made to understand by the applicant, these are the factors which comes in his mind, and then the decision also vary to certain extent from office to office. I'm not talking about office to office, even one controller to another controller also. It may vary, because if the controller is subject specific, say if he's from organic chemistry, MSc organic or PhD organic chemistry, and some data about, say, inorganic chemistry or something like that, so his interpretation will definitely have a change in weightage, or variation will be there. So that much comes, and I think we will, all the student of science will agree to that, because this person sitting behind the chair is also a student, is also a science student, is also an engineering student. So and he has not visited your plant. He has not exposure to how these R&D labs are carrying out these innovations, and what is the real background knowledge. Sometimes the applicant hide the facts. Now who will put the facts? That's why there is pre-grant opposition also.
If the applicant has not brought us the reality of the invention, the reality of the invention is he is alleging, this is my invention, vis-a-vis the prior arts available. Now he misses, many times he misses all these things, though he himself is aware of this, but he never mentions these are the prior arts. Now this has become a huge task. Imagine that you have never seen the plant, process plant, R&D efforts, R&D background knowledge, and it has not been also communicated to you, because prior art, mentioning prior art set your direction of a person who is very well unknown of all these matters. Now who will tell him? Prior art. That only will be direction. Now if you have not mentioned any prior art, examiner and the controllers are having a vast roaming jungle before them. So on today's time, it is vast jungle. I go to Google, if I select any word of your specification, paste it to my Google search, I'm in a trouble. Which document to select, how to know it, where to move, I'm in trouble. Examiner does his job, okay. It comes to the controller, another question before him, whether the search is correct. So he has to use his experiences. The applicant is not telling me anything. How can I come to know what type of R&D effort has been done? So all these matters. So that is why that is why still a great effort has to be there. That is only due to industry and all these people coming more closer, clarifying more clearly, distinctly. And there are many subject matters, and the difference of opinion will certainly come. And even I say that even if you are not satisfied with the evaluation, you are always free to file a review petition, and this is a better way out rather than going to litigation. First, you exhaust all the means which are available with you. So review petition is for this. So in your opinion, if the evaluation is having a miss, I will not say it is incorrect evaluation, a correct evaluation, but I will say if there is any miss, in your opinion, that if it is a miss of certain points which you have elaborated, you consider this as synergy, but still controller not agreeing, you can have a review petition elaborating all your facts, figures, and knowledge which was deficient at the time of first decision making. I think it will be better involvement.
Sir, I have a question regarding review petition. At the time of review petition, what is the status of the patent holder? Is that patent and its rights live or not?
No, suppose if it has been refused, then status is refused.
No, if it has been granted.
If it has been granted, then its status is granted.
And the application is still under review, or
no, who will? If the applicant has been granted the patent, why will file the review petition?
It is always the other party which has.
Other party will go to the not the review. It will go to the post-grant opposition. It will not go to review. Other person has not got any right for review petition.
Yes.
Thank you, sir. Thank you so much for the insight and for sharing the genuine difficulty which an examiner may face, or which the controller will encounter at the relevant stage of the proceedings. Thank you so much, sir. With this, we move on to the next presenter of the day, and we have Mrs. Survi Agarwal, the founder of School of Legal Education. So, Surbhi, I would request you to share your experience and insight as an IP practitioner and also as an entrepreneur.
Thank you, Mr. Gaurav, for this introduction. And before I begin, I would like to really thank Sir for his enlightenment, especially on the view of prior art. It was really very heartening, especially coming from a startup like myself. It's been a while though, but still 5 years. And I can still see how much dispute we are facing in patent applications vis-a-vis prior art. So good afternoon, everybody. I'm Surbhi Agarwal from School of Legal Education, and I'm honored to have been invited here today to primarily address two issues. Firstly, the industry perspective regarding IP vis-a-vis School of Legal Education. And secondly, as a woman entrepreneur, how has IP really affected my business decisions and the position of women at large pertaining to IP, that is women in IP. So we prepared a brief presentation also for brevity. So let us begin with an introduction on innovation and creativity. So innovation and creativity are nothing but engines of human progress. Since the beginning of time, female and male inventors and creators have transformed this world through the power of their imagination. So all the products that we actually enjoy today are nothing but a result of all the research, the development, experimentation, and invention. So they are all effectively the creations of human mind. So this makes innovation very, very important. We all know that. Now comes IP into play. We all know that intellectual property system, what it actually seeks to do. It seeks to achieve one main purpose, which is to encourage more innovation and creativity by making sure that creators like us can gain a fair reward too. Now coming to women and IP, societies all around the world have benefited from the work of women inventors, designers, and artists. But data shows that fewer women as compared to men actually use the IP system. That gender gap matters on many levels, primarily the reason being the gender inequality, which is prevalent if one agrees or doesn't agree. And also, don't we all think that the world will be better off when women and girls are more empowered and they can effectively use their human resource in the positive direction of innovation? Coming to the IP perspective regarding School of Legal Education, we call it SOL because it's easier to pronounce. The same was founded in the year 2017. SOL is a very unique initiative which is aimed to bring the knowledge of the Indian legal system to the doorstep of every person by way of e-learning through our website www.schooloflegaleducation.com. The main objective of SOL is to provide the law enthusiasts, be it lawyers or students, the immediate access to various laws that are practiced in the Indian courts. So School of Legal Education is nothing but a one-click guide to everything legal in India. It is, like I said, a user-friendly online coaching institute with exclusive focus on everything legal in India. All our courses are extremely concise, straightforward, visually appealing, which are otherwise boring in law colleges, we all know that, and easy to understand, and all are followed by certificates. Now the question arises that why was SOL actually founded? That is, what was the philosophy behind creating School of Legal Education? As a law student, which was almost a decade back, I always used to look around and search for additional assistance regarding the subjects that we were taught in law colleges. So unlike primary school subjects like mathematics, accounts, there were not many law tutorials available at the time. Moreover, the difficult COVID times have further complicated the pursuance of legal studies. In view of this, we have created School of Legal Education, which is basically, like I said, to provide an easy access to all the law subjects that are taught in law colleges. So since we are all now introduced to School of Legal Education, let us evaluate how important is intellectual property pertaining to startups like Soul. So whenever one plans to launch a startup, amongst the very few protections that one seeks is that of IPR. Intellectual property rights are crucial for businesses as they really drive innovation, resulting in the delivery of better services and protects its innovators and promotes consumers. When a startup protects its ideas, it is the only entity that can actually take commercial advantage of its patentable ideas. This allows a startup to create unique products and services that have a good chance of success in the market, thereby increasing profits and preventing their infringements and passing offs. Talking about startups, let us evaluate how Soul had protected its IP rights. Since a School of Legal Education is based on the framework of e-learning, and most of its property is in fact intangible, involving vast amount of original literature, audiovisual lectures, all intensively designed by our legal experts, protection of its IP rights had become extremely imperative. At the time when it was founded, which was 5 years ago, no such concept of online legal learning actually existed in India. Thereby, the concept itself is extremely novel and innovative when it comes to legal studies. So in light of this, we proceeded to protect the IP rights by filing all the necessary trademark and copyright applications of its brand, courses, course videos, ebooks, which are also now published and are sold on Amazon and Flipkart, thereby symbolizing what an intricate role IP has actually played in the formation of School of Legal Education. Now, coming to the next very important issue of today's panel, women and IP. So women entrepreneurship and women in IP are hand in hand and are directly commensurate to one another. Women contribute to all fields of creativity and intellectual endeavor, yet their achievements often remain hidden. The gender gap is all pervasive. Even in advanced economies like us, women do come up against the infamous glass ceiling, finding it very, very hard to climb at top. And if they actually climb at top, they are often paid less than their male counterparts. So the gender gap is also evident in education. Although progress is being made in encouraging girls to take up the STEM courses, which are nothing but scientific, technological, engineering, and mathematical subjects, still not many of them do become PhD scholars and further become inventors to file for patent applications. My team had gathered a few statistics in this regard. So the analysis by the World Intellectual Property Office shows that less than a third of all the international patent applications filed in the year 2015 included women inventors. That was although a very big improvement as compared to the 1995 figure, which was only 17%. So WIPO's data on patents and gender reveal a very, very encouraging trend. This graph does show that. Gender disparities are harder to measure in relation to creative works, such as books, music, films, because IP rights in those works are not always protected by way of applications, and copyright and related rights already exist since our statute provides so. Let us have a look at some of the prominent women entrepreneurs who have built their brands and are today extremely big names in the field of intellectual property. Did you know that 45% of startups in India are run by women, of which 50,000 are recognized by the government? The country has witnessed a vast women-led improvement as regards startups, turning them into unicorns in the year 2021. Some of the major startups which are run by women and need absolutely no introduction are Nykaa, Byju's, Zolo, MobiKwik, and I'm sure there are many more. In fact, Seoul was motivated by the concept of Byju's, which Byju's being for primary school students and Seoul being for lawyers and law students. So the question thus arises, how can we make the innovation system more inclusive and encourage more participation by women in the PCTs and IP as a whole? To start with, we have to understand a few factors that actually hold women back. Some of the barriers that come to my mind are maybe prejudices, preconceptions and stereotypes, or maybe the inflexible economic and social structures that are present which restrict women's career, the significant financial commitment which is involved in bringing up a startup, and also the presence of a usual bias, which is there, we accept it or we do not accept it. So there is plenty of evidence that increased participation by women actually improves the performance of organizations and societies. Research has shown that diverse, inclusive teams are more innovative and diverse companies are more profitable. In part, it is basically simply a question of numbers. By widening the pool of talent, one increases the chances of valuable new insights emerging. Also, women do bring additional new perspective to the industry. Coming to the end of my presentation today, I'd just like to say that there was a time in India where a woman owning a bank account was also considered a major benchmark. However, it currently has over 15.7 million women-owned enterprises today, most of them being very novel and taking IP protections in every field. So this drastic transformation clearly underlines the potential of women and their determination towards leading the industries and their IP rights. Thank you.
I'm quite stunned. There's hardly anything that's left for the other speakers when it comes to the women and the gender inequality perspective, which Surabhi has now shared. The statistics, I was just going through the WIPO data, which was shared by Surabhi. Asia remains the highest with 35% of participation by women in your entrepreneurship, while only 24% in Europe. But it doesn't look like that. If you look at the perception which is there, it looks like Europe has much more and much wider participation by women, and perhaps there'll be less in Asia, but the statistics reveal otherwise, which is quite startling, and that you've revealed. And congratulations on the promotion on Amazon and Flipkart also, which means that you, being a woman in IP, is leading by example and taking soul to places, and wish you good luck to promote it.
You flatter me, Mr. Gaurav. Thank you so much.
And now we have the next woman in IP. I would like to invite Mrs. Akansha Sharma now to share her insight as the head legal on behalf of EN Projects.
Thank you, Gaurav. Good afternoon, everyone. I'm Akansha Sharma. I am here to give you a brief presentation of how we industry perceive IPR. So I've prepared a small PowerPoint presentation. I will take you about what we do at EN and why IP is so important to us. As already discussed by Dr. Blossom Kocher and Mr. Neeraj Jindal, IP came to us as a reactive step and not as a proactive step. We discovered that our equipments were being manufactured and were sold, exported under a brand name which we were already using for a very long time. And then we at EN decided that we have to go forward, we have to register our mark, we have to patent our process, technology transfers, and we have to protect our IP rights. Starting with the presentation. Something about a company. What do we do at EN? We are one of the leading engineering companies in India for more than 2 decades now. We are a giant. We have experienced exponential growth in the domain of equipment manufacturing. We design, we manufacture a wide range of equipment for the following industries, whether it's dairy, confectionery, pharma, beverage, meat, FMCG, industrial architecture. Some key facts about our company. We have employees more than 500 in number. They're technically trained. We have our presence in 4 continents. We have delivered more than 300 projects. We have a dedicated R&D facility. They're tasked with developing new products each day, every day. We also try to make energy efficient products, tailor-made solution to our clients. Our R&D facility has been the cornerstone of innovation for our company. We've experienced an annual growth of 10% in the past 10 years. Our mission and our vision. We aim to raise the bar and set our own benchmarks, which would define the standard for the industry as a whole. Our vision, we envision ourselves as the premier equipment manufacturer, not only in India, but also on a global stage. These are some of our valued clients. If you will see, they are from the various industries, Mother Dairy and Amul from dairy, GSK, Amway from pharma, Yakult, dairy again, Kraft Food, Perfetti from confectionery, Ranbaxy, GSK from pharma, and so on and so forth. Now, what exactly do we do for these industries? Starting with the first industry, I'll tell you what we do for the dairy industry. You name it and we produce it. We do complete turnkey projects. Our products vary from milk, cheese, ice cream, ghee, yogurt, butter, buttermilk, flavored milk, probiotic drink, UTH milk, and much more. From the very raw material to the end product, we make the entire automated systems, whether it's storage, whether it's milk reception, storage, mixing, blending, pasteurization, fermentation, separation, and in the end, cleaning and process. The entire systems are designed, manufactured, and developed by us. Some of the recent projects that we've done, we've set up the Nestle Agro line. Sorry. How do I go back? No, before this. Yeah, sorry. So for the recent projects that we've done in the dairy industry, we've set up the Nestle Agro line, the Amul Tetra Pak line. What we provide them is the equipment such as butter churner, homogenizer, separator, bulk cooler. These are the examples of systems that we've done. This is the CIP system, the clean and process system. The UTH milk line. UTH is a technology where you take liquid food to very high temperatures, temperatures up to 135 degrees. So it makes liquid food fit for human consumption. Our prestigious clients have been Amul, Mother Dairy, Yakult, Danone. These are the wide range of equipment that we manufacture and design for the dairy industry. This is the example of a butter churner, homogenizer, CIP system, boiler, pumps, storage and mixing tanks. Moving on to confectionery industry, whether it's your chocolate, candy, or chewing gum, we manufacture it. We design, develop, build, install machines for chocolate processing, whether it's molding of chocolate, tempering of chocolate, cooling tunnels, spinning machines, all peripheral equipment are designed and manufactured by us. We aim to give complete automated production system to our clients. Some of the recent projects that we've done is we've set up the Kit Kat line, the Dairy Milk line, Mars, Candyman, the Pulse Candy. What we produce, what equipments we give them is the melter, duplex filter, batch cooker, cooling tunnel, wafer conveyor. Now you'll see that auto coater and Sigma mixer has been highlighted here. This is because our patent applications have been pending for these two equipment. Our prestigious clients are Perfetti, ITC. This is the example of the Sigma mixer and the auto coater. These are the wide range of confectionery equipments that we design and manufacture. Similarly, for pharma industry, We manufacture and design technically sophisticated products, whether it's embracing drums, containers, hopper, dust-free powder handling units, emptying systems of viscose products. The recent projects include Amway project in Madurai. We provided them with RO skid, tablet coating, multi-way system, CIP. Our clients have been companies like Ranbaxy, GSK, Abbott, Max. Some of the products and some site images are here. These are other products that we've done for other industries. In the meat industry, we've set up Ethiopia Slaughterhouse for Ilana Foods. This is what your poultry slaughter line looks like. For Pepsi and Coca-Cola, we've set up their Tropicana juice, real fruit juice line. We made mega kitchens for Nestle, Fresco. In Baddi, we have set up the Colgate, the toothpaste line. Similarly, in Guwahati, we've set up the hair oil and Chyawanprash line for P&G, Unilever, and Dabur. Our most prestigious project, and the project that has been very close to our heart, has been the water show at Akshardham Temple. If you've not already seen it, my recommendation to you that after this seminar, please go and watch that water show. It's one of a kind, truly. What is very astonishing about this, it's the world's first open-air IMAX 3D laser projection. We also hold patent on the technology where water and fire mix and explodes using biogas. Now, we are a company which is involved in equipment manufacturing. Everything is very technical for us, and it becomes very important for us to protect our intellectual property rights. At EN, we've taken following steps to protect our intellectual property rights. We've protected our brand, our trade name. All our equipment are marketed under the trade name of Astra. When it comes to equipment, we hold copyright on layout drawings, industrial design protection for our equipment shape and service patterns. Then comes process and technology transfer. As already discussed earlier, you can develop a patent, but it has to be usable. We as a company, we have industry, we have to market this process, this product. So many a time a client approaches us, they have a specific problem, and we have to give them a specific solution for their problem. Our R&D technology facility works day in, day out, making energy efficient solutions and providing them to our customers. Many a time these solutions are just ideas, inventive ideas, but then with more R&D, they can turn into concepts and then into reality. Reality means product and process. We filed various patent applications in the last 2 or 3 years. Some of the examples of our IP protection at EN is, this is an automated polishing machine. Our patent is pending on that. This is a cable tray designed and manufactured by us. We have copyright on the layout drawings. This is an example of floor drain system. We have industrial design protection for same, and Astra is trademark. That's our brand. Now, how at EN have we benefited from making our intellectual property portfolio strong? We get government support under the Skill India initiative. The government gives us subsidiaries. Your strong IP portfolio definitely increases the market value of your company. It opens doors for foreign collaborators and investors. Your export opportunities are increased. You get a competitive edge in today's market. Surprisingly, in 2020, early 2020, when the entire world was facing COVID-19 and China, which is one of the major equipment manufacturing country, was shut. This is where IP helped us a lot. We had a strong IP portfolio. Foreign investors, collaborators were looking for a country where there was man-force, where the IP rights were protected. And hence, our strong IP portfolio helped a lot to get foreign investors on board. They signed NDAs with us, and that's how IP helped us. Our strong IP portfolio truly has been a game changer for us. We've seen 18% increase in exports. We have overseas operations now. We have overseas offices in Canada and Dubai, and we are exporting our equipment to following countries. As already discussed, the government is also helping with intellectual property rights. Intellectual property right is the key for success for Make in India, Design in India. The new mantra is Creative India, Innovative India. The government provides following initiatives for startups: 10% rebate on online filing, 80% fee concession. IP procedures are now more compact, time-bound, transparent, and it's easy for IPR seekers now. The recent IP trends in India, very astonishing facts and figures. So 14.2 lakh trademark registrations were just filed in 4 years in the year 2016 to 2020, in comparison to 11 lakh trademark registration, which were passed over a span of 75 years. So we've come a long way. 28,000 patents were granted in 2021 alone, as compared to 4,000 patents in 13-14. That's a growth rate of 572%. The patent application time has been reduced from 72 months to 12 to 24 months in December 2020. And India's ranking in Global Innovation Index has improved to 48th rank in 2020, which was 81 in 2016, 2015 and 16. And by 2025, India aims to be in the top 25 nations of Global Innovation Index. Thank you. I hope my presentation was helpful, on point. Thank you so much for your time and listening to me.
Thank you, Akansha, for the lovely insight that you've shared and the illustration that you've shared with us for a successful entrepreneurship, for a successful business unit. You need to have a holistic IP protection. So the IP protection was not stopped by EN projects at a trademark registration of Astra. They went on to get the copyrights, design and patents also in place, which helps them get a robust protection of IP and ultimately results in a higher valuation of the company and a higher return on investment.
It came to us as a reactive step and not a proactive step.
So this is a learning that the MSMEs should take, and startups should definitely consider that if they from the word go, from the very inception, at the stage of incubation, if you are also considering IP as an important tool for your business and not only management and planning on your budgets and your marketing, etc. Of course, those are all essential components to your business, successful business. But the importance of IP cannot be undermined. And I'm sure people must have watched Shark Tank here. They're also, you must have seen how deeply the sharks used to emphasize on whether you have an IP or not. So
one point I would like to,
please.
Yeah. So what I also saw, that when you have a strong intellectual property portfolio, it's very easy to get bank loans as well.
That's another very important aspect.
Yeah.
I think I'd like to contribute a little bit that when you just mentioned Shark Tank, most of the startups like ourselves, it's like the first step that all the investors usually ask, are you IP protected? Do you have registrations? Do you have copyrights? So it is a very, very important mandate nowadays.
Indeed, this is an important step and a must consideration for all the young entrepreneurs, and that they need to keep in mind before they launch any startup or before they venture into any business activity. With this, I would like to now invite the fourth presenter on the panel, Mr. Anum Khan. She's a registered patent agent and a senior associate with United IPR. Tarunji, if you could share our insight. But it's already 4 o'clock, so by schedule, we are running about 15 minutes late. We'll try to wind it up by 4:15. Thank you, everyone.
Thank you, Gauravji. Very good evening to all the dignitaries present over here. I'm very much fortunate and privileged and honored to be speaking at this event. And I am truly thankful to Sudarshan sir for providing me this opportunity. So today I'll be sharing some of the key developments in the Indian patent law in recent times and its impact on the industry. So what is the motivation for a person or industry to file a patent? The patent are being filed, patent are being granted, in fact, with an objective to encourage the industry, startup and individuals to invent, innovate and develop a new technology and industry. So clear-cut motivation for an inventor or an industry to disclose their invention. The only motivation for such a disclosure is if they are properly being rewarded monetarily. Otherwise, they may opt to work it secretly, and the knowledge and creativity will be confined to a very few number of people. So with this objective, the patent law works both ways actually. That is providing exclusive rights to the innovators and industries for a certain period of time, side by side, benefiting the general public by bringing the patent knowledge in public domain. So what value a patent holds and its universal recognition that is being reflected by the ever increasing number of filings of the patents across the globe. There's a lot of filings internationally as well as on national level also. Patent filing has been increased enormously in the last 4 to 5 years. So before delving into patent filing and prosecution strategies to be followed by the industries for an effective grant of patent, I would like to throw some light on drafting aspects of the patent specification of an invention. As learned John Container also pointed very rightly, that specification and claims without proper drafting, how an examiner would be knowing what is being disclosed in an invention, via an invention, what is being disclosed. So patent specification and claims, these are the essence of an invention. And effective patent specification should contain claims duly covering all the aspects of the invention. So I'll try to exemplify it. Since patent laws are territorial in nature, it differs in each jurisdiction. For example, as per the Indian patent law, a method of treatment of humans or animals is not patentable, even if the statutory requirement of novelty and inventiveness is met with. However, such claims, if novel, can be allowed by the US Patent Office. So if a company is willing to cover multiple jurisdictions for the protection of its invention, it should certainly take into account the laws of such jurisdictions and accordingly should endeavor to claim all aspects of the invention, including the methods, the product, the composition, the formulations, the single compounds, and any other related aspect. Now, for a company to develop a robust patent portfolio, it has to keep certain things in mind. That is, what the company wants to protect, whether it's a whole product or just a part of it, whether the product or process is new, whether it is original or it possesses industrial applicability. Also, the advancements of the invention in question over and above the existing science also needs to be ascertained. These all being the statutory criteria of the patentability. Further, to save time and cost, the company should beforehand decide on which countries to cover. Deciding on which countries to cover would help in drafting the patent application in a way so as to include all the details as per the jurisdictional requirement, as I have already mentioned. So the ambit or language of the claims plays a major and decisive role in grant of a patent on an invention. So I personally myself have seen a lot of inventions that have been rendered non-patentable because of the language of the claims. Although the patent inventions, they were clearly novel, they were clearly inventive, but just because the language of the claims was non-patentable under the Indian patent law, those inventions were being rendered non-patentable and the patent was not granted. So Indian patent law in particular is very much strict with the patentability requirements, and sometimes it comes too hard on inventors or industries perspective, because somehow if the specification has not been written in a proper way, and then it all becomes too onerous task to in fact to present their perspective with the patent office. And with these, to overcome any disparity in examination of the applications, many guidelines have been issued by the Indian Patent Office for examination of inventions in various subject domains, such as biotech, pharma, computer-related inventions, inventions related to traditional knowledge. So this has tremendously helped put things in perspective and has also given a better understanding of the inventions to the examiners. So the issued guidelines also helps the inventors and patent professionals to understand the patent eligibility criteria of their inventions and what is required of them to disclose and claim. Further, timing also plays a crucial role in the launch of a product of a product patent. For instance, if a product is to be launched, the company will definitely want to at least get the patent application published. So Patent Office, by many recent amendments in the patent rules, have considerably reduced the timelines and simplified the process of filing, as well as many formal requirements have been eased down. So the patent applications are now being examined and granted or disposed of in an expedited manner. So usually the normal course of the publication is 18 months from the date of the filing of the application. However, this too can be considerably reduced to even a month by filing a request for early publication with the Patent Office. Similarly, the timelines for examination of a patent application have been substantially reduced. So every industry very much welcomes any such development which are aimed at simplifying the protection of IP rights, and especially in patents, because patents are the major revenue generator for any industry, and even for the Patent Office also, the patents have been the major revenue generators. So in Patent Office, Indian Patent Office, with a series of amendments in patent rules since 2016, patent rules have been changed quite a lot. And the Patent Office has implemented such amendments which have been specifically aimed to simplify the patent filing and prosecution process. So a few of the very notable amendments, for example, are fee has been reduced by up to 5 times. And due to such reduction in fee, there has been a considerable increase in domestic filing, and which has already encouraged the very young minds, innovators, the individuals, the natural person, in fact, to file for the patents. Before that, the innovators, or I would say that young minds, they shy away from filing the patents because of the fee structure. Now it has been considerably reduced for the startups and MSMEs, including the educational institutions. So that has been a very welcome change. For the requirement of formal requirements, actually, the Patent Office earlier required the submission of documents in original. Now that requirement has been quashed by the Patent Office. So this actually has been a very welcoming change for us attorneys and patent professionals, because this has simplified the e-filing process, and many of the deadlines, whatever the deadlines we were missing and petitions had to be filed, those deadlines have been taken very good care of, because now the Patent Office, when only required, then only we need to submit the original documents. So that has been a very welcome change for the industry also. Also, owing to recent amendments in patent rules, Patent Office has relaxed the requirement of filing of statement of working. This is actually a very welcome amendment, and has been welcomed very positively by the industry professionals also. Now, a single form can be filed for the multiple related patents for the statement of working of the related inventions, and requirement of filing separate forms has been waived off by the Patent Office. Further amendments in patent rules have also been done to expedite the examination of the patent application. Multiple criterions have been added for the eligibility of expedited examination, and inclusion of startup and a small entity along with the female applicants has been the highlight ones. So in the, I would also like to mention for foreign entities, there has been an inclusion of patent prosecution highway that has been included for the this expedited examination. This patent prosecution highway provides a patent applicant to file for the expedited examination if the office of earlier filing, if the patent application has been determined to be patent eligible by the office of earlier filing, then the applicant can file the request for expedited examination. Further, it is very noteworthy to mention that a lot of time and cost are being invested up to the grant of a patent, and the companies, along with the patent professionals, should also devise a vigil strategy to keep a watch on any sort of infringement of its patented products to weed out any potential threat. So Indian patent law provides a substantive cover of protection, and infringement proceedings can be initiated by way of filing pre-grant oppositions and by way of filing post-grant oppositions to potentially infringing patent applications or patents. Further, civil proceedings can also be initiated in case someone is directly copying, selling, or manufacturing the patented process or product. So it is actually of utmost importance for an industry to have a good protection strategy in place. The steps taken by the Indian Patent Office in form of amended rules have been truly commendable and should be properly utilized by the industry and patent professionals for driving the maximum benefits for their inventions. Signing off, I would like to mention about my journey in IP too. So as we are celebrating the women in IP today, I started my professional career as a researcher in agriculture field, and after a while ventured into this IP field and become a registered patent agent. Although my journey as a patent professional has been a short one, it's been quite extremely enriching and rewarding. And I have been very much blessed to be guided, trusted, and mentored by the best seniors in this field. I've also been blessed to be able to work on both sides of the patent laws, firstly as a researcher and then as a patent professional. And this has actually given me a better understanding to respect the invention, and in the meantime to guide the inventors for the best possible protection of their invention. So I look forward to exploring any new heights in this field. And thank you all for your time and patience. Thank you.
Thank you very much, Taranumji. It's enriching and very detailed technical insights shared by you, which I'm sure all the listeners will be benefiting from. You've drawn distinction between the US and Indian patent laws, which is quite important because when filing international applications, international patent applications in different countries, this is a consideration that we bear in mind, because there are certain things which are patentable in the US regime while they're not patentable in India. These laws are territorial in nature. So thank you for drawing that distinction. And you also mentioned about the reduced timing and the reduction in the fees, which has improved the number of filings and which will continue to encourage innovators, incubators, inventors to come forward and file their patent applications. So I have a small question on this aspect, because everyone in the previous panels also have been emphasizing on the increased number in patent filings, and we are foreseeing a vast number of patent applications which will be filed in times to come. Is our Indian Patent Office capacitated to handle the volumes at present, or in your opinion, do we need more examiners or we need more people to handle that, sir?
I will like to inform that we are deficient of patent applications.
At the moment.
We are waiting that people should file, and so that we can work in our full capacity.
That's good to hear.
So, no, patent application, number of patent applications. I'm talking about filing per year.
Thank you so much, sir.
So
it's good to hear
process
that.
will be carried out, no doubt about it. But as far as new applications are concerned, we are waiting that industry and all applicants will file more applications.
I'm sure these platforms and more such events will encourage the inventors to come forward and use the grant which is being provided to them, the reduction in fees, the improved timelines, and also the MSME benefits which are provided to them. So once we do more such sensitization on IP awareness, I feel that there'll be more number of
That initiative we are already taken for NEPAM, the awareness program, and we want to educate at least 10 lakh by the end of August 2022. So it's a great initiative, and I think we have achieved our 60 to 70% target by the end of March. So I think we are expecting we'll be meeting the target of awareness And by this awareness programs, we expect that more applications, patent applications will be filed, and we will have a work for new applications.
Thank you so much, sir. Thank you. Now with this, we come to the last presenter of the session and of the day, who will be delivering his thoughts on behalf of the Trademark Click, Vasant Chandra, Head Operations and Product, trademarkclick.com. Vasant, over to you, please.
Thank you, Gaurav. Being the last speaker of the day, I think everything is covered and touched. All my colleagues have shared their insights, and pretty much everything is done. So there's nothing much for me to say, but still I'm going to give my insights. So this venture that we have, Trademark Click, was started in 2017 by a young lady entrepreneur, Miss Meera Bansal, who happens to be here today. She has an experience of 25 years in intellectual property and majorly in trademarks and copyrights. This venture was started with the intention to make the entire process for the applicants easy and in a digitized mode to avoid all the paperwork. In the last 5 years, we have successfully seen and been a part of and on the journey with over 500 applicants for trademarks and copyrights who understand the importance of and who value their IPs in terms of for their business as well as individual intellectual property like domain names, etc. Now, with the change, a lot of people have mentioned about the rules which were changed. The trademark rules were changed in 2017. Patent law rules were changed in 16 and 19. And then we saw a lot of craze in both the individuals, startups, and MSMEs to protect their innovation, IPs. That's how they learn, and things were, opened up, and they now understand the importance of their respective IPs. And rightly pointed out earlier as well that IP should not be should be looked at as the frontline approach and not a thing which has happened, and we should go back to it and correct our measures. Recently, ministries have also started, giving a lot of grants to MSMEs and individuals. They have also offered discounts in terms of their professional fees so that more people come up and protect their intellectual property. People, just to say that people are aware about it and they understand the importance of it. I'm not going to go in depth of the fees, the technical figures, because I think everybody has already done that. So primarily in Trademark Click, we do two types of intellectual properties. One is trademarks and the other is copyright. There's some examples that I've tried to show here that what can be trademarked and what is not possible. This is the process of registration, which I'm not going to bore. It's been a long day. Certain types of copyrights. Again, the process. This page that you here see is a form which is available on our website. One can log into our website www.trademarkclick.com, fill up this form for trademarks. All the data that you put in here is captured at our backend, and this will ease your work that you just have to now track your application online, and all the work is done by us at the backend. Likewise, this is the form for copyright. And like I said, you just need to fill up the form and obviously pay your fees, because we also have to submit to the department, sir. And you just need to track your application, and we are there to be a part of your journey until the registration of your IP is done. Thank you.
One thing I may add on, see what the advantages of the trademark click. See what I have seen, if anybody needs an IP protection, he will go to a lawyer to file application. He will have to basically give the official fee and also the professional fee, the lawyer's fee. Now, what we have seen in the trademark click is, the many of the authors and inventors are coming directly. See, basically that makes the IP filing very, very cheap. See, instead of going to a lawyer, basically they can directly come to the trademark, they can file the applications themselves. That's the position. It is just like going to the trademark office directly. So, Vasant, can you highlight, like you're receiving many applications from the authors directly?
Yes, like I said, sir.
This is something advantageous. See, the position is that saves a lot of money. That saves a lot of money, and the author or the inventor or the applicant himself can keep track of the applications. The dependency upon the professionals reduces tremendously. So this is something what I get from you.
Correct, sir. Correct, sir. So like I said, sir, we have been a part of 500 applications for the applicants, for the authors, the owners of various copyrights. And they save a lot of on back and forth communication, coming to the office, a lot of paperwork is reduced. So we have tried to digitize to have an ease with the innovators and the applicants, so that they can focus on the work and leave the rest to us.
And then what else I have seen, in case some of the individuals, they want to file applications outside, that also become very, very easy for them.
Correct.
Then sale and purchase of IP, that is again a very important phenomenon in this. I saw the website where, I have some suppose designs, I have some artistic features which are already protected. So I'm looking for a licensee, I'm looking for the assignee. I want to transfer, I want to sell those. So one can basically visit this particular platform, one can post up his IPs, and one can always find a good customer for that. So this is something interaction that is happening. This is really helpful.
Yes, this is something unique that we have started, where one can sell and buy their IPs, be it their trademarks, be it their logos. Somebody who wants to license their work in terms of be it anything, be it a movie that you have scripted down, or a novel that you have put in, you are looking for publishers. So that's one platform that we have developed, and people are using it, and it has come to benefit to them. Thank you. Over to you, Gaurav.
Thank you, Vasant, for the nice insight on trademarkclick.com and for your expertise and experience. With this, we come to the end of the final panel discussion. And I would like to just conclude by saying that thank you all for being a wonderful audience. I would like to thank AIPLA. I would like to thank PhD Chambers of Commerce also for their invaluable support in organizing and in supporting this event, which is jointly and collaboratively organized by the PhD United IPR and the AIPLA. We look forward to having such interactions in future, and with more robust strength and with more online and physical participation. Just before we wrap up, I would like to now invite Kanchanji to felicitate the dignitaries on the dais. At the very outset, I would like to have Kanchanji to felicitate Mr. Neeraj Jindal from Safex Chemicals.
Thank you so much for coming. Very informative session.
Now I'd like to invite Kanchan ma'am to felicitate Ms. Surbhi Agarwal.
Thank you, Surbhi.
Now ma'am, please, if you can have a similar felicitation for Akansha Sharma.
Thank you, Robust, you have made your IPR portfolio robust because of the great. Thank you so much.
And
Experiences, and actually this is a learning experience for all the startups.
Yes.
See, we don't have to, IPR has to be taught at startup at the beginning only. We have to think.
So I would share one experience. The day we were granted our first patent, the mood in the factory was, everybody was like so happy. And then it only like motivated us to even like, work harder. So as Gaurav was pointing out, you will be receiving a lot of patent applications.
That's it. Kind of collaboration. They actually, everything, your valuation will go up with all this if you have a strong IPR portfolio.
Of course.
Gives that kind of credibility.
Definitely. It's an all-round reality as well.
Your experiences.
Thank you, ma'am.
now to Mr. Tarannum Khan. And now to Mr. Vasant Chandra. Sorry. And if you could just stay over for a second, and can I invite Sudarshan sir? Sir, please, if you could come and felicitate Kanchan ma'am for her robust and proactive. No, that's fine. Yeah, I would like to thank both Mrunmay and Premashish for their immense hard work on bringing this together and making it a success. Congratulations to both of you. Mrunmay, great work by you.